It's going to sign up. The living orders in the three. Mission. Yes. 23. Yes. Yes. You have intimated the other side. Okay, you are Mr. M. Doji, the learned counsel, appearing for Mr. T. Tang for the respondent submits that Mr. T. Tang is out of station. Therefore, he sought for some accommodation. He submits that he has already intimated the counsel appearing for the petitioner. Counsel appearing for the appellant. Prayer is allowed. Let the matter be fixed on when? After 2 weeks.
My lord, I want to mention item 13. The part I'm for the petitioner, the party has already settled the matter. So I want to withdraw the CRP.
Item number 13.
13, lordship.
Okay. Mr. You are?
R. Nabam.
Mr. R. Nabam, the learned counsel, appearing for the petitioner, submits that he has instructions to withdraw the instant civil revision petition. Accordingly, the petition is dismissed as withdrawn.
Lordship.
My lord, may I refer item number 12?
Yes.
My lord, we are to take steps. I am appearing for the petitioner. My junior who appeared on the last occasion, he has expired. So I need to collect the brief and then to take the steps, my lord.
Okay.
Item number 12.
Mr. Sudesh Kumar Singh, the senior counsel, appearing for the petitioner, submits that he is required to take steps here. The party is required to take steps in the instant petition. Therefore, he is seeking some accommodation in the matter. Where is allowed, let the matter be listed. When do you want it?
I will take at least 10 days, my lord, because I need to restructure my entire brief, my lord. After that, my lord, after 1 month.
2 weeks,
4
after 2 weeks, let the matter be listed. After 2 weeks on a date to be fixed by the registry.
My lord, if I may, my lord. My lord, in item number 12, my lord. Although service has not been taken, the trial is going on. So we have been informed regarding institution of this case before this honorable post. So if it may be allowed, they may serve us the copy, my lord, and we may find out.
No issue, my lord. No issue. We will do that.
You are Mr.
Jitalo, my lord.
You have instructions to appear in the matter.
Yes, my lord.
Mr. G. Talon, the learned counsel, appearing for the respondent, submits that he has instructions to appear in the matter. Appear in the matter, though. So a copy of the civil revision petition shall be served on him. You served him a copy.
My lord.
Much honored.
Admission hearing.
Lordship, I beg to mention item number 10.
Yes.
The leading counsel is having health issues. Leading counsel is having health issues, so not appear.
Having
health issues.
Mr. So and so appearing on you also there in the case.
Yes.
Mr. So and so appearing for the petitioner submits that the leading counsel in the instant case is not keeping well. Therefore, he seeks some accommodation. Where is allowed. Let the matter be fixed after 2 weeks.
2 weeks. Your Honor.
On a date to be fixed by the registry.
Lordship, interim may be continued.
Interim order so passed earlier shall continue till the next date of listing.
Much.
Lordship, item number 4.
Yes.
Here in this case, Lordship, along with this criminal revision petition, we have filed one IA also. It IA has not been listed. So direction may be given. Kindly, it may be.
IA is listed. IA is numbered.
Yes, 116 of 2025.
Okay. You have Mr.
M. Khambo.
Mr. M. Khambo, the learned petitioner, appearing for the petitioner, submits that the petitioner has filed an IA in the instant case that is being registered and numbered as
116 of 2025.
2025 in the connected connected criminal revision petition. However, the same is not listed today. Registry is directed to take the IA along with the criminal revision petition and list it after 2 weeks.
There is an interim also been interim order.
Interim order so passed earlier shall continue till the next date of listing. Twenty-four, 25 years. So we'll see, I mean, when the matter comes. No, upgradation will be difficult. Upgradation will be little bit difficult. Let's say, I mean, we have time. Let's see. I mean, what is the matter? What is the matter? You have intimated the other side.
Yeah.
You have intimated the other side. Let's see, I mean, better.
Item number 1.
My lord, in this, by way of civil revision petition, my lord, I'm challenging the impugn nil order dated 12th January 2026 and subsequent, my lord, nil order extended on 7th February 2026, my lord. My lord, straight away, my lord, I'll come to the next page 29, my lord, impugn order, my lord. Impugn order, my lord, page 29, my lord. My lord, we'll see at first, my lord, is the nil order. My lord, it's called nil order, kabang. It's a synonymous, my lord, everywhere.
So it's a summons or notice?
Yes, it is order as well as, my lord, notice, my lord. My lord, we'll see the first page, the primary property, my lord. That is the key catchword, my lord. Primary property, my lord, is situated Sonajuli Blaze, Pio Sonajuli, PS Balijan. My lord, from this, my lord, it is clear that property in dispute is situated in the Sonajuli Blaze, my lord.
Yes.
My lords, will see the who has issued this, the mail order, my lord, mail order, down below, and also in as the order head, my lord. Order it is issued by Tichi Bapi GB Gangbura Durpang Nishi Blaze, my lord. Durpang Nishi Blaze.
So that's a different village.
Yes, different Blaze, my lord. Durpang Blaze, and by
So
this,
he doesn't have jurisdiction.
yes, he doesn't have jurisdiction, my lord. As per the statute, and also in terms of the statute, my lord, the state has framed the guidelines, and there are also guidelines. He doesn't have it. And more of that, my lord, apart from having this part, having no jurisdiction, my lord, at page 38, my lord, he had also constituted inter-blaze territorial, my lord, blaze authority at page 38, my lord, last paragraph. Following shall constitute the judicial bench, my lord. He himself appointed as a presiding judge and other three as a co-judge, my lord.
The other three are from which villages?
Of different blazes, my lord. Not of Sonajuli blaze and the different blazes. But here, even in this case, even in case of inter-blaze customary court or blaze authority, this is the appellate forum under the statute, my lord, Civil Court Act. Being the appellate court, my lord, our forum.
So matter at the initial phase, it could not.
Yes, you're constituted because it's does not have an original jurisdiction to trial the case of the other blaze, my lord. First, this can be only taken up only if there's a decision of the blaze from the Sonajuli blaze. My lord, to see the same as at that page 79, my lord. This repetition on page 97, my lord.
Page
97, second.
Yes.
Page 97. This also, my lord, this is second subsequent summon or mail order, my lord. Same as it is, my lord, primary Sonajuli blaze.
First was issued on 12/6/2026. 12
12th January 2026
12
issued,
January
and second notice, my lord, on 7th February 2025, my lord.
26.
26, my lord, sorry, 26. Now, the same property, my lord, and also there at this, my lord, the second notice, they proposed to schedule that the proceeding is scheduled to be held on 4th March 2026 at page
By
99.
by the inter-village,
Yes,
Supreme
madam,
Court.
page 99, my lord. The date of hearing, madam, 14 March 2026, my lord. Now, at page, again, my lord, page 102, my lord. Same blaze, they have constituted the inter-blaze blaze authority, my lord. Page 102, my lord. Second paragraph, my lord. On day fixed 4th March, the following shall constitute the judicial bench. Again, my lord, the
Same,
my lord.
same members.
My lord, this, my lord, the first, this order, subsequent order, it was at page 104, my lord. This was dispatched by the GB Durpang Blaze on 27 February 2026, my lord. Although other it appears to be 7 February, but this was dispatched. This is the postal envelope, my lord. 10. Now, my lord will see under in the state of Arunachal Pradesh, as we have I already highlighted, my lord, there is every blaze has its own blaze authority, Gangbura, my lord. Now, in the present case, my lord, at present there's no GB in the Sonajuli blaze, my lord.
Because she died.
Yes, he not died, my lord. He tendered resignation.
Resignation.
But I'll come to that point, my lord. Now, at page 36, my lord, 136, the resignation letter accepted is page 36, my lord. Now, one Nabam Namoti, my lord, page 136, who was serving as a Gangbura blaze authority. She tendered her resignation on health issue, and her resignation has been accepted, my lord, by the authority, appointing authority, this deputy commissioner, on 6 May 2025. Now, my lord, see next page, 137, my lord. Agent today, there's no GB appointment has been done in respect of Sonajuli Blaze, my lord. This is certificate from the circle officer, my lord. This is to certify at present no Jeep Gangbura Shonsho of Sonajuli Blaze under Shonsho has been appointed after resignation tender by one Srimati Shonsho. The official process for appointment new Jeep Sonajuli is being processed, my lord. Now, under the situation, in these circumstances, my lord, I'll just refer the AP Code 1, my lord, Volume 1. In case if there is no blaze authority appointed, in that case, there's a procedure, there's a statute, my lord, provision provided as to what the mode should be adopted, my lord. Volume 1, my lord, page 1, Assam Frontier, page 150, my lord. Volume 1 of page 150. Assam Frontier Administration of Justice Regulation 1945, my lord. It's page 50, my lord. Page 50 of that volume 1, page 50, 50.
Yes.
Now, this is
Page 50, which rule you are referring to?
my lord, this is the statute
Yes,
governing the.
correct. No, which particular rule?
Now, my lord, page 52, my lord, section 5.1. This is regarding subsection 1 and 5 is regarding the appointment of the blaze authority
Correct.
by the deputy. Now, second, my lord, in case subsection 2, my lord. In any area for which no blaze authority has been constituted under the provision of subsection 1, the power and function of blaze authority as provided by this regulation shall be exercisable and performed by the deputy commissioner or the assistant commissioner authorized by him in this behalf, my lord. Now, here, in case if there's no authority, apparently, my lord, have seen that the Sonajuli Blaze, no GB has been appointed after resignation, my lord. Now, again, subpara 3, my lord, you see, the state government has framed the rule, my lord. The state government may frame the rule, guideline for or any matter as may be deemed expedient, including election, selection, appointment, power and function, and meeting of the head GB, my lord. In terms of subsection 3, my lord, the government has framed the rule, my lord. Rule I'll take straight away, my lord will see. Page 115, my lord, of my affidavit, in my petition, man, 115. It's type copy, my lord, 115. This is the guideline governing, my lord, framed in terms of subsection 3 of the section 5, my lord. My lord would see regarding power of civil justice system, my lord, at page 123, my lord. 123, this is clause, subclause A and clause of clause 7, my lord. Let's talk about power on civil justice, my lord. My lord, it says HGB will try all suit without limit of value in which both.
So within the village.
Yes, within the village.
Hmm.
Now, again, my lord, at page 124, my lord, clause J of, subclause J of the clause 7, my lord. Intervillage, Kyabang, my lord, this intervillage is the appellate forum, my lord.
So the case which could not be settled in the village, so may be referred to Bango.
Bango means inter-village territorial, my lord, village authority, my lord.
Correct, I got
Like,
it, got it.
accordingly, apart from that, this, my lord, the provision in consort and as per this in statute, my lord, under Civil Code Act 2022 Amendment Act, my lord,
Mm.
is also, it is specifically provided, my lord, you see page 144 of my petition, my lord. This is the Amendment Act 2022 of Civil Code Act, my lord.
Yes,
At, my lord, we see page 145, my lord. This amended 145 of third para, my lord, Roman 3, my lord. After fourth proviso to subsection 3 of section 5, the following subsection shall be inserted, my lord. Subsection 4 has been inserted by the virtue of Amendment Act 2022, my lord. Now, appeal from Blaze Authority, if agreed to by the parties, shall lie before the inter-Blaze customary court, appellate court, which shall be settled by the Choncho, my lord. Now, this, my lord, as the word, my lord, agreed to by the party, my lord. This has been further again amended by way of Amendment Act 2023, that whosoever even agreed to or agreed by the decision can approach the inter-Blaze territory, my lord, customary court. At page 147, this is the Amendment Act 2023, my lord, para 13, my lord, see. Amendment of Arunachal Pradesh Civil Court Act, so this is amended in year 2023, my lord, Gazette published on 2023. Now, Arunachal Pradesh Civil Court Act, my lord, in section 15, in subsection 4, for the word if agreed to by the parties or if agreed by the parties or if aggrieved, party desired to be appealed as the case may be, shall be substituted, my lord. Not only whosoever even agreed by, they can approach.
yes, you have, if you are agreed by the village village code, then you'll have to approach.
Yes, yes.
You
Now-
have the right to approach the Bengal level. Bengal
Yes,
level is the inter-village, court.
But in this case, my lord, the absolutely the Durpang Blaze, my lord, the Gangbra doesn't have a jurisdiction, and even assuming they have constituted inter-village territorial customary court, that also doesn't have a jurisdiction because they are
There are
Appellate
appellate
forum.
forum.
yes, ma'am. But this they can just
No, at this stage, I don't think, I think we'll issue.
only on the
notice.
point, madam, if this such kind of orders and null and void ab initio, madam, Honorable Supreme Court has repeatedly held, madam. It's gone to the root of the case, madam. It can be challenged any point of time.
Mr. Koyu, right?
My lord, I'm T. Tagum.
Titagam. Heard Mr. Titagam, the allied counsel, appearing for the petitioner. The instant civil division petition has been filed by the petitioner, assailing the legality and validity of the impugned mail in stroke near NYEL order number GB. You can take it from me, dated 2012-12026 and extension mail stroke Niel order dated 7/2/2026 issued by Sri Teki Bapi, the Gaungura of Durpang Nishi village, Bandedeva, for adjudication of purported property situated at Sonajuli village, being illegal and without jurisdiction. The case of the petitioner is that the property in question is situated in Sonajuli village, wherein no village head is functioning at this point of time. Close to piece of point of time. This is the case of the petitioner that one Srimati Nabam Namoti, who was serving as Gauri of Sunajuli village, has tendered her resignation from the aforesaid post on 3/3/2025, which has been duly accepted by the concerned DC, Papumpari district by acceptance letter number so and so dated 16/5/2025. The petitioner's case is that since no one has been appointed as Gaura as per which code? As per
As per Assam Frontier Administration Justice Regulation 1945.
45, and the opposite Teki Bapi, the Gaura of Dupang Nishi village, does not have any jurisdiction. Does not have any jurisdiction to issue any mal order in the instant case. The learned counsel appearing for the petitioner submits that it has been verified, it has been certified by the concerned circle officer that no one has been appointed as a village head of Sunajuli village till date after the resignation of Nabam Namoti. Therefore, the aforesaid Teki Bapi, who is not a Gaura, who is not a Gaura appointed as per the terms of AFR 1945, he doesn't have jurisdiction to issue the aforesaid impugn mail orders. Full stop. He further submits that
He's appointed, but he's from different places.
correct. He is not appointed for this village.
Yes, ma'am.
He submits that by the aforesaid order dated 12/1/2026 as well as 7/2/2026, the Gaura has also constituted an inter-village community,
Customary court.
inter-village customary court for adjudication of the dispute. He submits that power is not. He submits that power of constitution of inter-village customary court is not with the village head of a different village.
Right.
But he doesn't have power.
He doesn't have a
He
power.
cannot constitute an intercourt. That
Even
has to be
yes.
constituted under the AFR by the DC.
Yes, ma'am.
Correct. So he doesn't have power.
He doesn't have a power.
Inter-village customary court has been constituted by the aforesaid Gaura without having any jurisdiction. In view of the aforesaid, he submits that the impugn mail/Niel order dated 12/1/2026 and 7/2/2026 should be stayed at this stage. Full stop. In the state of Arunachal Pradesh, every village has its own Gaura, having appointed by the DC of the concerned district under section 1 of section under section 1 of the AFR,
Subsection 1 of section 5.
under subsection 1 of section 5 of the AFR 1945. The aforesaid Teki Bapi being the Gaupura of Durpang Nishi village, which is a different village and doesn't have any connection with the property which is situated in Sonajuli village, does not have jurisdiction, does not have any jurisdiction to adjudicate and preside over the property dispute pertaining to Sonajuli village. It is also seen that he has constituted. He has himself constituted an inter-village customary court beyond his jurisdiction, as the same has to be constituted by the concerned DC as per the AFR rules, AFR 1945, correct?
My lord.
Correct, no? DC has to constitute
My lord,
Intercourt?
my lord, in case there's DC has to, my lord, ultimately, or the circle head is there, Gangbra also there, my lord.
Gambro can constitute.
Yeah, Gangbra, my lord, if they are appointed for a particular place, my lord, say for circle, for there's a Gangbra circle, Gangbra, or in absence they are, my lord, DC they can.
What is the last line?
My lord. My lord, there's already the forum they've already constituted, my lord, and in the entire circle, my lord, there's one Gangbra authority who can constitute, my lord. But none of he's the not one, my lord. One Tichirkaya is the Gangbra who has been constituted to look up.
Then you write he has constituted the inter-village customary court without having an authority in terms of AFR rules to 1945 full stop. Taking into consideration the submissions made by the learned counsel, as well as going through the materials brought before this court, this court is of the considered opinion that matter will require further consideration. Full stop. In view of the aforesaid, let notice be issued on respondent number number 1 by speed post, as well as on usual process within a period of 3 days. Full stop. In the meantime, the impugn mail Niel order dated the 2 dates. The 2 dates are stayed until further orders.
Item number 2.
My lord, this is an application, my lord, joint application filed by the petitioner, my lord, both alleged victims and alleged,
So husband and wife,
not husband and wife, my lord.
What?
They are close family relatives, my lord.
or some assault happened, no?
Yes,
some
yes, my
fight
lord.
happened.
My lord, this FIR, my lord, FIR was lodged on 25 July 2020, my lord. We'll see at page 29, my lord. This is the FIR, my lord. Page 29, my lord, type copy. This is the FIR lodged by the first petitioner number 1.
Then a cross affair.
My lord, cross FIR was also lodged, my lord, because incident, my lord, is arose out of, my lord. First, this complainant's son has assaulted the elderly person of the alleged accused person, my lord. And against that FIR, another FIR has been lodged, my lord. That was registered, my lord. And 29, my lord, again, second and same incident, my lord, the 2 FIR, my lord, page 31, my lord. Another FIR, same incident, my lord, this was registered, my lord. Since this is arising out of same, my lord, this 2 FIRs of same date, that is lodged by petition number 2, that was clubbed together, my lord. Then case was registered, my lord. Thereafter, my lord, during the pendency of the case, my lord, the party have they have conveyed
Settled the issue.
settled, my lord.
Hmm.
At page, my lord, the 141, my lord, the settlement, my lord, page 41. The other case, my lord,
Page 41.
Yes, page 41, my lord. They have settled, my lord, before in presence of Blaze Authority, my lord, with the interpretation of the all elderly friend, my lord. It's linked with. So- It's linked.
Where is the second FIR? Page
Second FIR is
Page-
page, my lord,
31.
31 type copy.
Mayanabam is who? Mother, Mayanabam is,
Is
one is Namanabam, one is Mayanabam.
Maya Naba, my lord. Is the wife of
Naba.
yes, no, not first one, but it's the wife of the cousin brother's wife of the petition number 1. That's the first complainant.
Acha, Adam Nabam.
Adam Naba, my lord.
He's the wife of Adam Nabam. And like
Yes.
they have broken the vehicle of Adam Nabam also.
My lord. Because the allegation, my lord, petition number 1's son, my lord, Luis Naba, my lord, just beaten one Lali Tatsang, my lord.
So how many boys were there? I mean, Thomas Tachang, Marcus
My lord,
Tekitara,
6, my lord.
Huh?
Altogether, my lord, 6, my lord.
Marcus Tekitara, then Mohan Tekitara. Only 3 are named over.
Yes.
Thomas Tachang,
Mohan Tata.
Mohan Tachang, Kame Teki, Marcus Tekitara. So 4 in the second FIR and like 3 in the first FIR,
My lord.
correct?
Yes, ma'am.
But there are common names, Thomas Takang,
Yes,
Marcus Tekitara and Mohan Tekitara common.
my lord.
One says Mohan Tachang, one says Mohan Tekitara. Which is correct?
Mohan Tachang, my lord.
So ultimately four persons have been, four persons have been named,
My lord.
5 persons. An agreement by
My lord, all
44. Hmm?
agreement by
Thomas, Marcus, Mohan Teki, Tado Tachang, Koli Tachang, Kametechi, 6 people.
my lord, there's a charge, the charge sheet, my lord, their name is there, ma'am.
Now, what is the stage of the case?
My lord, the just first someone issued, my lord. In charge sheet, my lord, the investigating officer, this settlement was brought to their notice, and there to that effect, they have reflected in charge sheet also. They have resolved the matter, my lord, in the charge sheet itself, my lord. And some of them also, they have said that they are not involved, my lord. Now, the
Charge sheet has space.
charge sheet, my lord, it starts from page 46, my lord. But relevant, my lord, it is operational to 59 onwards. 59, my lord. And last paragraph, my lord, see. After
46,
this last paragraph, my lord,
49,
59, my lord,
59.
of the charge sheet is operating,
Yes.
my lord, last paragraph, my lord, see. But on 29 September 2025, my lord, this charge sheet was filed on, my lord, on
12 November.
yes, my lord. And this order.
Now, how can it be that it's not 12 November?
Madam, this
Aha,
forwarding
12 November.
forwarding is the 12th November, but charge sheet it was from the concerned IO is on 23 October 2023, madam.
23 October.
Yes, And that charge sheet was forwarded to the trial court, madam, on 12th November, madam. The statement of the charge sheet, my lord, at last paragraph, my lord.
Yes, but on 29.
But on 29, my lord, complainant of the instant case submitted a letter through OC PS Sijosa regarding the settlement of the instant case in their blaze level through Nyel, my lord. Page 59, my lord. This is noted, my lord.
Yes, yes.
They have settled, it was intimated by the complainant. Also, after settlement of the case in Blaze, complainants Nabam Nama and two.
Okay, Mr. Hage, MS Hage. Hmm. Hmm. 59. No. Where? Page 59, which paragraph? One second. Complainant has after settlement in the village, complainant Nabam Tama, two witnesses so and so submitted their request. Now, where are you reading? No. Where are you reading? Page 49. Which paragraph? Second last paragraph, which portion? Hence, I beg to submit. Into charge sheet. All accused person, Thomas Tachang, his name is there. Kameteki is also there. Tado Tekitara name is there.
Tado Tachang is there, madam. Tado Tachang. No. Madam, this pronunciation, madam, there's a funny, only pronunciation or phonetic difference.
The father's name? 49. Where is the agreement?
Tatang, madam.
Agreement is at page?
Agreement is at page 41, my lord. Tado Tachang, Tatang Tachang is there, madam. Page 41, my lord. Serial number 4, my lord. Siri Tado Tachang.
Tado Tachang,
Son
Tatang
of
Tachang.
Tatang Tachang, my lord, is there.
But here the name is Tado Tekitara and
Madam,
Tatang Teki.
my lord, that is this is prefix, and prefix is always but added in the particular
The
claim.
learned APP also will be knowing.
Yes, my lord.
He is a local girl.
She knows, my lord.
Huh?
Suppose
Then see why she is confusing.
say Tana Techi, they are Tara is prefix, showing their.
Okay, all the people are there. I think we can compromise this case. I mean, it's not a huge, it's not a kind of a heinous crime or whatever. No, almost all the people are there. If they have.
That club together.
See, in the first affair, I'll tell you, first affair, there are Thomas Tachang, then Sri Marcus Tekitara, then Mohan Tekitara. Correct, these three people are named. In the second affair is Thomas Tachang is there,
Yes.
Mohan Tachang is there, then Kameteki is there, and Marcus Tekitara is there.
Yes.
In the charge sheet, there may be some other different names because after the investigation, they have included some other names. But your concern is that like whether this person is there or not, whether agreement has been properly done or not, settlement is properly done or not. Correct. So Tado Tekitara was not named in the affair.
My lord, not named, but in the charge sheet.
Charge sheet name is come. And in the agreement, his name is there.
He's also there, yes,
You're saying that his name is there.
yes. Four, serial number 4 of 41.
And there are two agreements, huh?
Malad, two and first agreement is Malad is in respect of the son of the petitioner number 1. Malad. He was accused in the particular case, Malad. But here in causing, it's not here, Malad. That's also been resolved, Malad. The page 36, Malad,
Mhm.
two agreement. The page 36.
Lalita Chang and this thing. Louis Kamka Nabam,
Yes, Malad.
son of Naba Nabam.
Yes,
So
Malad.
this was a different case or same
It's a
thing?
different case, madam. Just for reference, this the charge sheet they have brought, madam. The other FIR, madam, on the first incident, madam, that Mohan Tachang was assaulted by Louis, madam. That is the son of the petition number 1, madam. And again, this FIR was lodged, madam. And that is also resolved altogether, madam. But in present for questioning, madam, we are not concerned with this.
So you are saying Tado Tachang is Tado Tekitara same person?
Yes, madam.
Hmm?
Yes.
Okay, take down. I heard Mr. So-and-so. Tabat Dagum, head of the Tabat Agim, and the learned counsel is hearing for the petitioner. And also heard Ms. Telhage, the learned APP for the state. The instant criminal petition has been filed jointly by the petitioners, praying for quashing of charge sheet number 8/2025, dated 23/10/2025, under section 324 in bracket 5/331 bracket 2/332 bracket small c /351 in bracket 2/3 in bracket 5 of the BNS 2023, arising out of Sejosa PS case number 06/2025 corresponding to GR case number 46/2025, pending before the learned Chief Judicial Magistrate, SEPA, East Command District, Arunachal Pradesh. Next, the instant case originated from an incident which occurred on 24/7/2025, wherein some altercation between one Louis Nabam and one Sri Lalita Chang occurred regarding certain suffering plans which were allegedly dragged by a tractor driven by the aforesaid Louis Nabam, in bracket son of the petitioner number 1. However, the altercation escalated into a physical scuffle, and during which Sri Lalita Chang sustained certain injuries. Full stop. Subsequently, on 25/7/2025, certain relatives of Sri Lalita Chang, including the petitioner number 3 to 8, came to the residence of petitioner number 1 and allegedly caused damage to a parked vehicle belonging to Maya Nabam, alias Maya Talk, in bracket petitioner number 2. It was also alleged that it was also alleged that one Alto vehicle belonging to one of the complainant, that is Nabat Abam, belonging to the informant, namely Namat Nabam, was also broken by the persons named in the FIR. Consequent to the incident, 2 FIRs dated 25/7/2025 were lodged by petitioner number 1 and petitioner number 2, respectively, against one Sri Thomas Achang, Sri Marcus Tekitara, Sri Mohan Tekitara in the first FIR, and against Thomas Tachang, Mohan Tachang, Kame Teki, Kame Teki and Marcus Tekitara in the second FIR. Since both the FIRs arose from the same incident and filed on the same date, both the FIRs were clubbed, and Seojasa PS case number 06/2025 under the aforementioned sections were registered. Full stop. The next para, the police, after investigation, filed a charge sheet. Filed the charge sheet dated
23 October 2024.
filed the charge sheet dated 23/10/2025, being numbered as 8/2025 against the following persons, namely Sri Thomas Tachang, Sri Kame Teki, Sri Tado Tekitara, Sri Kholi Tachang, Sri Marcus Tachang Tara, Sri Mohan Tachang, and Sri Mohan Tachang. Okay, make it Mohan Tachang. Before the court of subjudicial magistrate, before the chief judicial magistrate, SEPA, West Coming District, correct?
Yes, ma'am.
So SEPA, West Coming District, which is pending disposal, which is pending trial. Full stop. The learned counsel appearing for the petitioners submits that the root cause of the matter was a very minor issue, and thereafter, after a small tussle between 2 persons, the matter aggravated, and the families of rival parties got involved. Full stop. However, the differences between the parties have been amicably settled with the intervention of village elders and family members. And accordingly, a mutual settlement agreement dated 25/9/2025 was executed between the informants and the alleged accused persons in presence of village authorities, which was duly registered before the executive magistrate, Sejosa, Pakke Kesang district in accordance with local customary practices. He submits that the aforesaid settlement was accordingly intimated to the investigating officer. However, since the matter relates to non-compoundable offenses, a charge sheet was not compoundable offenses. The charge sheet number 8/2025 dated 23/10/2025 was filed against the petitioner numbers 3 to 8, wherein the settlement arrived between the parties was also specifically mentioned. Full stop. He submits that the issue, though relates to non-compoundable offenses, this High Court has sufficient power under Section 528 of BNSS to quash the proceedings pending before the Chief Judicial Magistrate, SEPA, as the same has already been settled between the parties, and going ahead with the trial will not fulfill any purpose, and the same will be a futile exercise. He submits that the rival parties belong to neighboring villages, and they have been peacefully residing without having any grievances against each other. In view of the aforesaid situation that is prevailing presently, he submits that this court should invoke the power under Section 528 to quash the criminal proceeding pending in the Court of Chief Judicial Magistrate, SEPA, West Kamen District, Arunachal Pradesh. So later part will do one thing. There has to be some case laws has to be referred to. So I'll pass the order. Okay. The factual part is, I have dictated. I think there is no problem with the factual part. So other part, some case laws has to be referred to, because we have stated about the Supreme Court cases.
Yes, Madam, para 12 onward, I've also mentioned certain citation, Madam, in my petition.
Okay, then we have been passing the order.
Madam,
So
Madam,
we'll see. Accordingly, we'll pass the order.
Madam,
Okay. This will be allowed.
Madam, deeply obliged.
Then Yabbi, so that is there with me. You also have it. Yeah. Okay, she's having that, so you can take it back.
Item number 7 is a bail hearing.
See, we are taking the bail hearings before admission, because admissions take time.
So this is an application trying for granting of
Bail.
default bail. Yes.
Huh?
Default bail.
What?
Default bail.
Default bail.
Yes, Lordship. Yeah, the section involved is 21B, 27 capital A, 29 of NDPS, Lordship.
How many days you are inside?
Lordship, the accused person was arrested on 30th May 2025 and 180 days completed on
30th May.
Yes, 30th May
13 or 30?
30.
30
05 of 2025.
Okay, so now
There are
more than 180 days.
Yes, Lordship.
No charge sheet file.
The charge sheet has been filed, Lordship.
File when?
Charge sheet was filed on 2nd of December 2025. I've also filed the bail application on 2nd of December
Okay,
2025.
that was the case
Yes, yes.
where, I mean,
Yes, Lordship. You,
Uh,
in the previous occasion, Your
I mean,
Lordship
that we have heard it some.
yes, has directed to
Earlier.
submit.
Have you seen that case law?
Yes, yes, Lordship.
What is that? What is the case law? You give me the citation.
Yes, Lordship. Relevant para is in paragraph 38 and 39, Lordship.
1 second. Para?
38 and 39.
You should always write on the top of this. When do you give it? It's always better. I mean, because sometimes when you give the citations, paragraphs, the judges may forget. So it's always better if you write it on the top.
The other one I have
Hmm?
given here, the other one.
My lord.
Okay, both.
Same judgment, but
Same judgment.
different journal, my lord.
Okay, here, I mean,
Paragraph, everything same, my lord.
GLT para
Paragraph, my lord, 38 and 39, my brother is referring.
38 and 39.
Yes, my lord, it will, actually it is from 37 only onward.
Yes. So, I mean, what is the ratio laid down?
My lord, here, what exactly the honorable, our court has held, the coordinate bench, my lord, for the purpose of computing the statutory period of investigation, my lord, the date of filing of the charge sheet would be the date when, my lord, the charge sheet is received by the concerned magistrate himself and with an endorsement, put a signature on the register or his seal, my lord. In absence of that, then when it is placed and seen by the magistrate. So now, my lord, to ascertain whether it was on register, it was duly endorsed by the magistrate or not. For that, my lord, register the scan
What is the process? How it goes? I mean, when a charge sheet is filed,
What, my lord, what usually the practice is, my lord, the concerned IO, he will prepare the charge sheet, my lord, investigation complete, then he will provide it to the SP, my lord. From SP office, my lord, it will go to the GR, my lord, the room where this charge sheet are usually received by the, my lord, from the home department itself, my lord. The GR or
GR court where in the court premises.
yes, court premises, and from there, my lord, again it will be go to the, my lord, the office of the, my lord, the concerned court, my lord, the CGM, my lord.
In the GR court, is there any registry wherein they put their signatures and receipt and a logbook?
Yes, my lord, the register they usually maintain, my lord, and as well as, my lord, in the court also, my lord, the court have their own registry also, my register.
So
also.
when, I mean, it is received in the GR office, then after receiving in the GR office, then accordingly it will be sent to the court,
Yes, my lord.
concerned court.
Yes, my lord.
And concerned court also have a register.
Yes, my lord.
They keep a register and they sign it that is received.
Yes, that is the standard practice. But in this case, whether it has done or not, that has to be looked into. Whether the charge sheet, when it was received, whether the concerned magistrate has put his signature or seal or not, that has to be looked into. If not done, then the order, the date when it was seen, placed before the court and seen by the magistrate, then that will be considered as a filing date of the charge sheet, my lord.
But in this case, I mean, I think the charge sheet was sent on 31st or 30th.
Charge sheet was sent on 2nd of December 2025. On the very day when the
Second, it was not second.
My lord,
as per record, it was sent on 1st of
as per the impugn order, my lord, your lordship will find in page number 36, my lord.
It was sent on first.
yes, first on
It
paragraph
was
4,
placed before the court on 5th.
on 2nd.
On second, yes.
In paragraph 4, my lord,
Oh,
will
sorry,
find.
on 3rd, Lordship.
It's written, my lord, the learned is submitted on completion of investigation. The IO has submitted the charge sheet against the accused person by charge sheet number so and so dated 29/11/2025, and the same is received by this court on 1/12/2025. It is submitted that the present bail application is filed on so and so after submission of the charge sheet, and the accused is not entitled for any benefit of default under so and so. It is further submitted that there is charge sheet against the accused person and the court may take cognizance and trial may be proceed against the accused. So, my lord, here we have to ultimately find out the date, my lord. When it was actually received, my lord.
It was merely received by the office of the court, lordship. From this very order, we can understand that it was received only by the office of the court on 1st of December 2025. Thereafter, again in paragraph 5 also, lordship, you can see that I have carefully pursued the case record and seen that IOS submitted the charge sheet against
Where, Srira?
paragraph 5, lordship, the continuation of the bail protection order. I have carefully pursued the case record and seen that the IOS submitted the charge sheet against the accused person before any bail application filed by the accused person. As such, the accused person is not entitled for relief of any relief of default bail. Here also, nowhere it has been mentioned that the case has been the final charge sheet has been endorsed.
No, that issue was not before that court at that point of time, because this case was not brought to the notice of that
Yes,
of
absolutely.
that court.
Yes,
So
What happens in practice, lordship, in trial court as of now, is that the charge sheet has been charge sheet is given to the submitted to the GR room, and there in GR room, the problem is that I have personally seen it. And the problem is that they only enters the date. However, they do not enter the time of the receiving of the charge sheet first. Thereafter, it is sent to the office of the court, which is received by the person who also take care of the filing of the bail application. So when we file the bail application, default bail application, they checks whether any charge sheet has been filed or not. If the charge sheet has not been filed, then only they accept the default bail application. Otherwise, they intimate the advocates, that the counsels, that the charge sheet has been filed. On
No,
that
but,
very particular day,
Hmm.
Yes, Lordship, on that very particular day, I myself had filed this bail application, and on the afternoon hours, in the morning hours, I filed it, and afternoon hours, I have received the information that the charge sheet has been filed. On next day, it was listed for motion on that is in, I can see in annexure 9, page 32. It was listed on 3/12/2025. However, after hearing this case, the order was given only after a month, lordship. I've also annexed the application file for CTC in annexures 10, page number 35, lordship. It was only received on 19 January 2026.
Paragraph 35, what is
Page
it?
number 35, lordship.
You filed it on?
The matter was heard on 3rd December 2025.
Ah.
However, the order was only received on 19 January 2026. Now,
From where are you saying so?
in the down below, received by HFA advocate on so and so.
But order must have been passed earlier, because it was
Yes,
it was dated 3/12.
Be that as it may be, lordship, but from one thing we can say that on paragraph 4, it has also been mentioned that the charge sheet has been received on 1/12/2025. However, lordship, it is pertinent to mention that on 1/12/2025, both the courts, the High Court as well as the trial court, were closed on the occasion of indigenous fate day. So there is no possibilities that the charge sheet could have been filed on that very particular day, because the entire
No, High Court is closed, but whether GR court will be, GR room will be closed. No.
that particular, the entire office was closed, lordship, on the eve of indigenous fate day, lordship. So, lordship, even if we consider that
No,
the
at
same
this
as
stage, see, we'll have to verify this.
We have, my lord, only verification has to made whether on that day, on the particular day, it was received by the magistrate or not, my lord, concerned magistrate or not.
Those
If
with-
not, then he's entitled. If it was received by the magistrate on second of before the filing of his application, then my lord, he is not entitled. It's only to, my lord, verify whether it was received by the magistrate on or before the filing of the application, not by the GR office or not by the register or not by the court officer, my lord. Only with the concern with the magistrate, my lord.
The magistrate has to put a sign also that see,
Yes.
Yes, my lord.
has
Yes.
put up before him.
Yes, my lord. Absolutely.
lordship,
That's
yes,
what
one
is supposed.
relevant paragraph is in paragraph 34, lordship. The Assam manual rule.
What my humble submission will be, my lord, may call for the, my lord, the copy of the register of particular date, my lord. So as to verify. If no signature, nothing has been made by the magistrate, then, my lord, the order passed on 3rd will be considered as the first day when it was seen by the magistrate, my lord.
The proper procedure has been mentioned in Assam Police Manual Part 4, Rule 38 and 69, lordship. That has been specifically mentioned in this order in paragraph 30, Lordship.
What is rule 38 and 39?
Rule 38,
Don't read it from here, whether you have seen it personally. Or, I mean, what is 38 and 39 of Assam Police Manual?
yes, I read 38 as well as 69, Lordship, and which has also been mentioned in this order, Lordship. In the judgment, Lordship, in paragraph 31, it has been.
38, they have mentioned about this. I mean, what is the contents you have seen there? It is there, the contents.
Yes, Lordship.
Well,
31. Paragraph 31, Lordship.
paragraph 31.
Yes. Now the question therefore arises as to whether forwarding the report of the office of the magistrate / the court competent to take cognizance of the offense would be sufficient compliance. The answer to same can be found in Rule 38 of the Assam Police Manual Part 4, which is quoted herein below. 38. Rule 38. First, information reports and final report forms by whom to be laid before the magistrate. First, information reports and final reports form must be laid as they come in before the district magistrate or magistrate in charge of police cases at headquarters and before subdivisional officers and subdivisions by which officers are detailed below. Number one, first information report by the second court officer under bracket sub-inspector or assistant sub-inspector, both at headquarters and subdivision. Two, charge sheets by the officer who prosecutes or watches the case. Three, final report forms by the second court officer under bracket sub-inspector or in the absence of assistant sub-inspector at the headquarters and subdivisions where there is a court inspector at the headquarters.
So what is important is that the officer putting up these forms
Yes, and the last paragraph.
before the magistrate.
Yes, is responsible for obtaining
So
the
we are
latest.
concerned with charge sheet, not with the final report. Correct?
Yes,
Because it's not an FR, it's a charge sheeted case.
Yes, ma'am.
So charge sheet by officer so and so, it's done. FR is different. The officer putting up these forms before the magistrate is responsible for obtaining letters initial or either.
or order either on the form or on the magistrate's general register, as the case may be.
Yeah, that they have to do.
Yes, Lord.
The officer who is filing the charge sheet.
Yes, Lord.
Then,
They're responsible to take the endorsement and initials.
so whether sign is there or not, we do not know as of now.
Yes, madam.
And then what is
69.
69
That is in paragraph 33, Lordship.
paragraph?
33.
Hmm.
Now coming to Rule 69, it would be seen that as soon as the final papers of the case as received by the court officer, whether it is charge sheet or the final report form,
Hmm.
he will fill in columns 10 to 14 of the register and again submit it with the final report or the charge sheet to the magistrate. The magistrate thereupon, if a charge sheet has been submitted, will either take the case on his own file or will pass orders to be entered in column 15, as to which the magistrate is to try the cases. This Rule 69 also would show that it would be duty of the court officer to place it before the magistrate concerned, and upon conjoint reading of Rule 68, Rule 38 and 69, it would show that the Assam Police Manual categorically mandates that it is the magistrate who has to put the initial as regard to the receipt of the charge sheet and in the general register, and not the ministerial staff or the court of the court magistrate.
So we can seek a report from the
Yes, my lord.
concerned CGM.
Yes, my lord. My lord, not the concern, the special court, NDPS, my lord.
Special court.
My lord, the scan copy of the register, my lord, which was recorded on 1/12/2000.
Let him submit a report before this court. Why should we go through all these things?
Yes, with
Let him submit a report along with relevant documents.
yes, my lord. That will suffice.
When he has received it, when he has signed it.
Yes, my lord.
Lordship, along with the scan copies of the register, as my brother has-
Absolutely, my lord. They will send it
Of
to support his.
of GR room as well as
My
the filing section.
So he will submit a report. Stating all these things. When it was received by the GR office, when it was sent to him, when he has signed it.
And
Yes.
when the bail application was filed.
No, that not required. That is to be decided by this court, my lord, basing on that report, my lord.
Worship, from the register of the filing section only, we can see that this bail, when this bail application was filed.
It's on second
that we
only.
can see.
It was filed on.
Anyway,
second.
let him submit a detailed report.
Yes, my lord, absolutely.
Then we can consider it.
Yes, my lord.
At this stage, that has to come.
Yes, my lord.
Worship.
Please heard Mr. So the learned counsel appearing for the petitioner, accused applicant, also heard Mr. TAT, the learned APP for the state. Then you like this is an application under so and so. An FIR dated 9/2/2024 was lodged before the officer in charge, police station, Chimpu. One second. You can take it from there. Page 26, paragraph 3. Paragraph 2 and 3. 2 and 3. The learned counsel appearing for the accused applicant submits that he had filed a bail application. That is bail application number 523/2025 before the learned court of the special judge NDPS, UPR, Arunachal Pradesh on 2
Yes,
on 2/12/2025, and the same was taken up by the aforesaid court, aforesaid learned court on 3/12/2025,
yes.
whereby an order was passed rejecting his claim for default bail. Full stop. The learned counsel appearing for the accused applicant submits that while filing the bail application, he was intimated by the office of the learned court of NDPS, special judge NDPS, that no charge sheet was filed at the point of time when he filed the bail application. Full stop. Accordingly, he submits that since there was no charge sheet filed at that point of time, he was allowed to file the bail application, and accordingly he moved the bail application on 3/12/2025. He submits that his bail application was rejected on the ground that the IO had already submitted the charge sheet against the accused person in the instant case. He submits that the learned special judge NDPS has recorded in his bail rejection order that charge sheet number 104/25 dated 29/11/2025 was received by the learned special judge NDPS on 1/12/2025. And since the since the bail application number 523/2025 was filed on 2/12/2025, the accused applicant was not accused applicant is not entitled, was not entitled to any default bail. Full stop. That is a submission, right?
Yes.
Full stop. He submits that the Honorable Guwahati, a coordinate bench of the Honorable Guwahati High Court, in its order, High Court, in the case of Samsul Noor, alias Samsul Noor versus State of Assam, reported in 2022 5 GLT 405, has specifically held that the timing of receipt of the charge sheet has to be counted on the time and date when the concerned court actually looks into the charge sheet by putting his signature in the charge sheet. Is it correct?
Initials and date.
Putting his initials and date. No, I mean, if the court receives it and the court officer signs it and keeps it, but doesn't place before the magistrate, then that doesn't help.
Yes, my lord. Here, two situation has been, my lord, discussed by the court.
Correct. Now, one is the court receives it and he puts a signature that I have received it. Court receives it, court
Yes.
office.
In
But it was not placed before the magistrate.
yes, my lord.
And he keeps it for a day. He forgot. Then what happens? So ultimately, the timing will be when the charge sheet is put up before the magistrate,
Yes.
and magistrate puts his initial and writes sin there.
In the my lord, in the charge sheet, and if register is maintained in register, my lord. Register is also there, my lord. Because, my lord,
The
as a,
register has already mentioned in his register that I have received it.
my lord, but there is a case, the case wherein coordinate bench has decided,
Hmm.
there, my lord, the signature was not there. In the
Sin was not there.
my lord, in register, my lord.
Register was also not there.
Yes, in the register, signature was not there, but it was first placed before the magistrate, when it was put up before the magistrate, before the court. That date was considered as the date when it was filed, because the signature was not there on the date when it was received, actually, is the list to have received.
The ratio says what? I mean, if it is, had it been signed by the court officer
That will not suffice.
in the registry,
That
that will not suffice.
Yes, madam.
So, if there is a register being maintained for signature of the magistrate,
Yes, madam.
then magistrate has to sign in the register.
Register, yes.
Or if there is no register is maintained, then what? He will sign in the charge sheet.
Charge sheet, yes.
Is
Yes,
it
ma'am.
so?
Yes, my lord. As per this judgment, my lord.
That's what I'm asking. So ultimately,
My lord, I will just read out one line, my lord. It's very clear.
Yeah.
Put the initial in the charge sheet as well as the register maintained with the date and.
Which para?
My lord, 38, my lord.
38 where?
Yes, my lord. The third last paragraph, my lord.
Mhm.
Put the, it is only when the magistrate, the
Yeah,
court.
no, which line?
My lord,
It would be the date
yes, my lord.
on which the charge sheet, no.
My lord, it is rule 38 and 16 of the Assam, so and so. It is
Comprehensive cognizance of offense puts the initials in the charge sheet
it as well as
in the register
register.
maintained with a date and seal
As a magistrate.
or a magistrate. It will be the date. So it will be both he'll have to do both the things.
Yes, if suppose, my lord, the magistrate miss out the register, then charge sheet will be, the date which has been put in the charge sheet will be counted, my lord. Or if it is not put in this charge sheet, if it was first placed before the magistrate, before the court, then the date when it was placed before the magistrate. My lord, para 39, your lordship will find the same situation. In the instant case, it is seen that it was only on 7/6/2022 when the charge sheet in question was placed before the court. And there is no material available wherein the special judge Karimganj has put an endorsement with initial and date as regard to the date of receipt of the charge sheet. Consequently, therefore, 7/6/2022 would be the date on which it would be deemed to the charge sheet has been submitted.
So there was no signature. So whenever it was put before the magistrate.
Yes,
taken as a date.
absolutely, madam.
It was taken
Yes,
as a
madam.
date. And in this case also, if there was no signature, then
It was put on.
Then third, my lord.
then it will be third.
Yes,
Then
sir.
third, my
Then
lord.
it will be termed as third.
Yes, my lord. Then he will be entitled, my lord.
Hmm?
Then he will be
Then
entitled.
he'll be entered.
Yes, my lord.
And all efforts of investigation officer goes,
Yes, my lord.
Huh?
Yes, that,
isn't it?
yes, my lord.
So whom to be blamed?
Actually, it's the duty of the magistrate if it is filed well within the time, my lord. So far as this manual and this,
Because investigation is officer also does some work. He also, he also does lot of hard work
yes, my
in
lord.
the dead hours
Yes, my
to
lord.
file them to submit the charge sheet
Yes, my lord.
in time.
Yes, my
He submits it,
yes, my lord.
but somehow it was not placed before the magistrate
ma'am.
or magistrate did not
Yes,
sign it.
yes, my lord.
So his all effort goes
Yes, absolutely, my lord.
for putting him behind
Yes, my lord. Absolutely. And my lord, the
and he is
magistrate,
seeing the benefit.
and why magistrate endorsement has been given, my lord, this significance here, because there is a possibility of, my lord, manipulation by the other officials. That is the reason, my lord.
It's very, that's very important.
Yes, my lord.
Now they will say that we have filed it such and such day.
Yes, my lord.
And it will not be placed before this. Both the way, manipulation will be both the way.
Yes, absolutely, my lord. Absolutely.
And what was the last line? No, read the whole line. The last line. Count. In the charge sheet or the register. No, or nahi hoga.
As well as.
Okay, no, as well as in the register maintained with the date and seal of the magistrate stroke court. Full stop. It would be the date on which both the aforesaid are complied with by the magistrate would be the date on which the charge sheet has been deemed to have been submitted before the magistrate stroke court. Full stop. Mr. T. Ete, the learned APP, has submitted the case this TCR, right?
Yes, my lord. It is-
Submitted the TCR before this court.
But-
However,
But
from
it
the
is through registry, my lord.
Huh?
TCR is through registry, my lord.
TCR you have received, no?
No, my lord, it is through the registry only, my lord. It's before your lordship, my lord, not.
Okay,
That's-
correct.
Yeah.
Correct. No, the TCR was, TCR in the instant case has been received. Have you gone through it? No.
My lord, I've seen it, my lord, in the charge sheet, no signature, nothing is there, my lord.
No, I have also gone through it. Yeah.
Yes, my lord.
Nothing-
They're more concerned about the register now, my lord.
Only about the dates.
Yes,
there,
absolutely.
order dates were there.
Yes, my lord.
That a TCR received, TCR submitted received by this court has been perused. However, this court could not find any material as to material which can be conclusively stated for timing stated as the timing and date of receipt of the charge. Full stop. As this court could not find any initial of the concerned court in the charge sheet as well as in the charge sheet. Full stop. In view of the aforesaid situation, to actually find the date of filing of the charge sheet, the relevant facts and materials would be important. Full stop. Right, number one, the registry maintained by the GR office, right?
GR office.
GR office of the concerned court, wherein the charge sheets submitted were received and recorded. Received and recorded.
As
correct?
well as court register, my lord.
No, one thing, one and two.
Yes.
Then number two, you write. Secondly, you write the register maintained by the court. Maintained by the court for receipt of the charge sheets, which are being forwarded from the office of the GR, from the GR's office. So there will be one register only in the courts of
Yeah, in courtroom, one register, my lord.
one of the register,
Yes,
because
ma'am.
that register will be only placed before the
Yeah.
court.
Yes, my lord.
Court makes
Yes,
one.
madam.
So these two will suffice. And
This-
second,
yes.
thirdly, the date on which the bail application and the date and time, the time and date when actually the bail application was filed
Yes, ma'am.
by the applicant in the instant case. Full stop. Therefore, it is directed to the concerned special judge, that is special judge NDPS UPR, to submit a report, to submit a short report as regards to the aforesaid facts, providing the timing and dates of receipt of the charge sheet filed in the instant case. That is charge sheet number. That is charge sheet number
104 of 2025.
104/2025. 2025. It is also directed that the relevant scan copies of the aforesaid two registers should be also made a part of the report. First, the
Also, three registers, Lordship.
white read,
The one GR room, the other the register maintained by the court, and one the filing of the bail application wherein the register.
filing will be there, they'll give the date.
Lordship, why I want to bring this before this court?
Okay, you write, then you write, the scan copy of two registers along with the register maintained by court office, right?
Yes, Lordship.
Maintained by court office of filing of bail applications. Bail applications on the, bail applications.
Specific date, my lord, has to be given, like,
You have stated,
Of second December.
2nd December, madam.
register on 1st and 2nd December.
Yes, ma'am.
1st and 2nd December respectively. That will do probably.
Yes, that will suffice, ma'am.
The report along with the aforesaid scan copies to be sent to this court by the registry within a period of
1 week, madam.
Lordship, and fixed date may be given, Lordship.
1 week. If it is 1 week, then again this court will not be there, then he'll have a problem.
Lordship, fixed date may be.
Today is Monday.
Yes, madam.
4 days are enough for you.
Yes, madam, it's upon the magistrate now. madam. It's upon the magistrate, madam. But then with the other cases also, madam, that is why I just seek for 1 week time, madam.
Now, if 1 week happens, if 1 week is given, then this court will not be there again.
Then, my lord, let it be on Friday, then, my lord. This matter won't take much time, my lord.
Friday will be difficult. No, within a period, you're right, within a period of, submit the report within a period of, today's
Today's
9,
Lordship.
9th, madam.
9, 10, 11. Within a period of 4 days from today,
Okay.
that is on
12, 13, madam. From today, it's 1, 2, 3, it's 12 then.
Lordship.
12.
So-
on 12th.
Yes,
So that
madam.
matter can be listed on 13, Lordship.
On 12th,
Yes, ma'am.
3/2026. This instant order to be communicated to the concerned special judge, NDPS, UPR, who will communicate?
My registry, my lord.
The registry to communicate this instant order to the concerned special judge, UPR, at the earliest. At the earliest. At the earliest during the day, during the course of the day.
Yes, ma'am.
At the earliest, during the course of the day. Let the matter be fixed on 12,
13.
No, 12 will.
13,
12, oh,
13, 13/3/2026.
Yes, ma'am. Obliged, ma'am.
Item number 8. May I please? That on the basis of the order passed by this honorable court on the last date, my lord, I have appeared before the investigating officer, and I have also submitted an intimation of cooperation also, that I am ready to cooperate with the investigation as and when being called for.
So you were the headmaster,
Head teacher, my lord.
head teacher, and some suicide.
Suicide by the minor in the hostel, my lord.
So this order was, interim order was what, to what effect?
But no course of action, since I had to attend and supervise and monitor certain examination which are being carried out. And in fact, on the last occasion, matter could not be taken up properly, since due to paucity of time. Otherwise, my lord, there's nothing incriminating against me, and there's no allegation or there's no fingers pointing towards me. And on the date of the incident, I was not there at all. So the question of abatement does not arise at all.
The exam is over now.
Examination is still on, madam. Last date would be, my lord,
Yes, Mr. Lowy, what is to be done?
Lordship, as per the status report, Lordship, what the IO stated that since owing to the ensuing board exam, the minor statement of the minor was not examined, and today is the last date of Lordship. So, if with strict terms and conditions, not to contact with the victims, with the minor witnesses, and not to intimidate Lordship. No, I have no objection with Lordship. And the Lordship, here is the case. And I also praise that the applicant should not leave this ICR, Lordship. Okay.
The applicant is from outside.
no,
No,
I'm
no.
from here. I'm a
You're
lady,
local person only.
local,
Yes.
my lord.
The last one, Lordship. The status report, Lordship.
I'm a lady teacher, my lord, and I'm ready to comply with any terms and condition.
Last page is the Lordship of bail comment, Lordship. Last page, Lordship.
Last previous is what?
Bail comment, Lordship.
Statement of whom?
Before filing of Lordship, this application, their statements already recorded, Lordship.
His statement, I mean, her statement was recorded.
Oh, yes, it's already recorded before filing of this application. Lordship.
And like suicide is all, victim is no longer there.
Yes, Lordship. Minor witnesses, Lordship. The student.
Some other
Lordship.
minor.
Yes, Lordship.
Okay, we'll let him, I mean, he's a teacher, we'll let him go
Yes, Lordship.
because this, we can make it absolute.
Yes, Lordship.
And she will cooperate and like, we'll put in some conditions.
Yes, strict condition, Lordship.
Three conditions means which are,
Lordship, as per the comment of IO Lordship, that
ICR means what?
Itanagar Capital Region Lordship.
Okay. An area to, okay.
The fourth point, Lordship.
Hmm. Okay, we'll consider this.
Yes, Lordship.
Grateful.
Okay, take down. Heard Mr. Jarin, the learned counsel, appearing for the accused applicant. Also heard Mr. L. Loy,
Deloy.
D. Loy, the learned learned public prosecutor for the state. This is an application under so and so, you write, huh? Then you write an FIR was lodged on 24 to 2026, alleging inter alia. Then you write like this: an FIR was lodged on 24 to 2026 before the officer in charge, Doimuk Police Station, Papumpari District, by the elder brother of a minor student of government girls residential school, Mitpu, Doimuk, alleging that on 21 to 2026, the food served in the hostel was not properly cooked and several students had to remain hungry. It was alleged that since they were hungry, some of the students, including the informant's sister, went outside the hostel premises to buy foods for them. Semicolon, that on their return to the hostel premises, they were intercepted by the teachers and hostel warden and confined them in a room for some time as punishment, during which they were reprimanded and threatened with intimation to their parents, semicolon, that due to such incident of humiliation and mental distress, the minor victim became really pressurized and mentally distressed, and subsequently committed suicide, leaving behind a suicide note referring about the incident and the conduct of school authorities. Next one, on receipt of the aforesaid FIR, Doimo Police Station case number 21/2026 was registered under the aforementioned sections. Under the aforementioned sections. Petitioner is the principal or warden?
Teacher head, my lord.
Huh?
Teacher head.
Teacher
Head
head.
teacher, my lord.
The instant pre-arrest bail application has been filed by the petitioner, who is the teacher head of the aforementioned school, and she is in the helm of affairs. For the ongoing which examination?
My lord, she has been appointed as Center Superintendent for ensuing AP State Board Examination 25-26 in respect of Class 5 and Class 8, my lord.
She is the head teacher of the aforementioned school, and she has been appointed as
Center Superintendent
Central Superintendent,
for conducting AP Board State Board Examination 25-26
25-26.
in respect of Class 5 and Class 8.
Class 5 and Class 8, and she has been performing her duties, aforesaid duties at present. Full stop. Well-learned counsel appearing for the accused applicant submits that since the FIR was filed and she was one of the teachers teaching in the aforementioned school where the unfortunate incident happened, being apprehensive, she filed the instant pre-arrest bail application before this court. The matter was heard, and the full stop. The bail the anticipatory bail application was heard by a coordinate bench on 27/2/2026, whereby the honorable coordinate bench directed the investigating authorities not to take any coercive action against the accused applicant till the next date fixed. Full stop. He submits that as per the terms, but there was no direction to
No direction.
appear
No,
before the court.
But however, since after this protection, my lord, I have appeared on 1st March 2025.
After such, he submits that after such interim protection, the accused applicant has appeared before the investigating officer on
1st March 26, my lord.
1st March. Is there anything on in the case diary?
I have the
No, lordship. Her is not already recorded, lordship, prior to the filing of this bail application, lordship.
It was recorded earlier also,
Oh,
but I
rather
have the
than-
receipt
Yes,
copy of the intimation.
Okay. submits that he already appeared before the investigating officer on 1st March.
Yes, madam. First
On
March.
1st March. He further submits that the accused applicant, the statement of accused applicant had already been recorded, and she is fully cooperating with the investigation, full stop. He submits that since she is a respectable teacher of the school, and she was, and she's no way connected with the unfortunate incident. She should be allowed she should be allowed to go on pre-arrest bail. He further submits that in the FIR also, in the FIR, there was no mention of her, or there was neither any mention of her, nor any allegation against her of committing any offense that has been registered against her. That not registered, the offense as has been alleged in the FIR. In view of the aforesaid, the learned counsel submits that she should be allowed to go on pre-arrest bail. Mr. D. Loy, the learned PP, has submitted the case diary before this court, and has fairly submitted that submitted before this court, and fairly submitted that she has already given her statements and cooperating with the investigation. Yes. Next, this court has gone through the case diary that has been produced before this court, as well as heard the submission of the counsel appearing for the respective parties. Full stop. It is seen from the records, it is seen that in the FIR was not named, further. There was no allegation of direct involvement of the accused applicant in the unfortunate incident that occurred wherein a minor girl had to lost her life. Full stop. It is also seen that due to the ongoing examination, several minor students, the statements of several minor students could not be recorded as yet. Though the statements of the accused applicant and some of the students have already been recorded by the investigating officer. Some of you write accused applicant, some of the teachers and some of the students have already been recorded. Taking into account the whole facts of the matter in its entirety, and the cooperation that is being rendered by the accused applicant till date, which has been admitted by the learned PP, this court is of the considered opinion that the accused applicant should be allowed to go on pre-arrest bail at this stage. Accordingly, it is directed that in the event of arrest of the accused, so that extension is not required, coercive action, so we'll allow you to go on bail.
Yes, with strict terms and
With some
conditions.
conditions, directed that in the event of arrest of the accused applicant, in connection with Doivuk PS case number 21/2026, she shall be released on furnishing of a bail bond of rupees 50,000 with two sureties of like nature, one of whom should be a government servant to the satisfaction of the investigating authority, subject to the following conditions. Number one, so there is no need of, she'll have to go and furnish it. So you appear before the, number one, you write, that,
Event of arrestment.
otherwise also you go and appear.
Right.
And you can intimate this order.
Right.
She shall appear before, the investigating officer within a period of 10 days of passing of this order. Next, you write,
No contact with the lordship.
he shall not try to contact the victim and the family of the victim, as well as other minor girls who may be directly or indirectly other minor students of the school.
Yes.
Other minor students of the school who may be directly or indirectly connected to the unfortunate incident. Number three, the accused applicant shall not leave. I think that is not required.
Yes, lordship, but I afraid for, that's why I afraid for
I
lordship.
think
Yes,
it's over
but
plan. I don't
yes.
think, that is required.
yeah, lordship.
That will be cut, that will be something like I'm giving bail and at the same time, her all freedom is, curtailed.
Yes, lord.
That the accused applicant shall cooperate with the investigation and make herself available as and when called for by the investigating officer. Then accused applicant shall not hamper and temper. That will do.
Yes.
In view of the opposite direction, the instant the application is disposed of.
Grateful.
Definitely.
Item number 9. It's a similar nature of application, my lord, and the other one is the teacher, my lord.
Same.
Same order, my lord, with a different name, my lord.
Her statement recorded. I want to-
He is
Statement has been recorded.
Huh?
Yes, recorded.
Recorded.
lordship. Yes, it is there in the lordship, city lordship.
Then same order we go. You just change the name and see the teacher. So the head teacher and teacher. And all other things will be same. Statement recorded, conditions also same.
Great.
It will be also disposed.
Yes. Definitely.
But was there any interim order in this?
No, similar order, my lord.
Similar order
Similar
was there.
No course of action.
Same order, same day, same order.
Same day. Item number 11.
Yes. Eleven, I think,
My lord, implement has done, my lord, the one IA was there which was disposed of, my lord.
but this, cost title has been done.
Yes, my lord,
Really?
they plague, my lord, the plague mark is there, my lord.
Okay,
Yes, man,
now they have included this
complainant, my lord.
complainant.
Yes, my lord.
This is a POXO matter or what? No.
No, my lord, here, my lord, actually, the accused has been made as an approver. Later on, it was withdrawn. They are challenging, it was not done as per the procedure of the law.
Okay, no one is appearing, we'll pass it over.
Okay, man.
None appeared for the petitioner when the matter was called for. Let the matter be listed after a week.
Okay,
However, Mr. APP is present.
oblige, man.
Item number 14.
May I please, Your Lordship? Your Lordship, in item number 11, I am for the applicant here.
The order is passed already, next week. Anything you have to say?
No, Your Lordship. With regard to respondent number 2 services, still, Your Lordship.
It never responded, service is not completed.
No.
So you write, Mr. So and so appeared on behalf of the petitioner. Service on respondent number 2 is yet to be completed.
My lord,
service report.
that is not reflected in the, my lord, main petition. In IA, my lord, the note, office note says so, but so far as the main revision petition is concerned, there is no any noting as such, my lord, whether they have taken
IA is for this thing, huh?
the for implement, my lord. Implement part done, my lord. So now in
You have
main,
taken steps or not?
Yes, sir.
That-
In the main case.
my lord, may
taken
kindly,
steps.
consider the office note in the main case, my lord.
Learned counsel for the petitioner has imputed complaint number so and so. But there is no steps.
Yes, my lord.
No, your
Nothing is reflected.
You write as Mr. So and so appears for the petitioner. And Mr. T for the state. The office record doesn't reflect about taking steps on respondent number, taking steps for notice on respondent number 2. The counsel appearing for the petitioner is directed to verify the same with the registry and accordingly take steps if the same is not taken as yet. Okay,
Obliged.
within 3 days, huh? Within 3 days. Within 3 days, you write. Release the matter after 2 weeks.
2 weeks, my lord.
After 2 weeks.
Obliged.
Item number 14.
Hmm? Service is still awaited. Mr. So and so is present on behalf of the petitioner. Petitioner. Office note dated 6/3/2026 reveals that service in respect of respondents numbers 1 to the report of service on respondent numbers 1 to 12 are still awaited. Let the matter be listed after 2 weeks. Interim order so passed earlier shall continue till the next date fixed.
Item number 15.
Lordship, in this matter, Lordship, investigation part is complete, Lordship. The charge sheet is ready to file. But Lordship, due to this order dated 2/6/25, Lordship, the Honorable Court has directed
2/6.
that no charge sheet shall be filed without the leave of this court, Lordship. So, this court.
2/6, which date?
Lordship, 2/6/25, Lordship.
2/6/25.
Yes, Lordship.
What is the order?
Lordship, here the operation order is, Lordship.
Posting of the impugned FIR.
Yes, Lordship.
Lodged by so and so. The FIR revealed that the listed false the signature of so and so.
Lordship, this criminal petition was filed for the quashing of the FIR, Lordship. But in the meantime, the investigation part was complete, Lordship. So on charge sheet ready to file, Lordship. So, but this order dated 2/6/25.
No, why this order was passed? I couldn't understand.
Lordship, actually, Lordship, what happened, Lordship? There is, Lordship, some because, Lordship, the investigation part was not complete at that point of time.
No, not
Lordship.
completed, but like, I mean, investigating as authority is always at liberty to file.
Yes, Lordship, but this, because of this order, Lordship, the charge sheet could not file, Lordship, because in this order it is reflected that no charge sheet shall be filed without the leave of this court. But the interim was granted.
Heard
that no-
Mr. So and so, the learned counsel appearing for the petitioner, also heard Mr. Ms. L. Hage for additional PP for the state. You are appearing for somebody.
For the respondent number 2.
Huh?
Respondent number 2.
And Mr. So and so for respondent number 2. Ms. L. Hage, the learned APP, submits that in the instant case, the charge sheet is ready to be filed
Yes,
by the
sir.
investigating authority. However, since an order dated 2/6/2025 was passed by a coordinate bench, directing that no coercive steps shall be taken against the petitioner
And no charge
and,
sheet.
and no charge sheet shall be filed without the leave of this court,
Yes, Lordship.
the same could not be filed as yet.
Yes, Lordship.
Full stop. In view of the opposite, the learned APP seeks leave from this court to file the charge sheet in an instant manner, full stop. Leave is granted, leave is granted, the investigating authority is at liberty to file the charge sheet in the instant case.
Yeah.
Instant case, full stop. On submission of the charge sheet, on submission of the charge sheet, the registry, I mean, you have called for this thing, TCR has been called down.
No, Lordship, charge sheet not been yet filed. Lordship.
No. Case that is called for.
Lordship, case that he was called for, Lordship, it is already here with me, Lordship. But
Then a charge sheet has to be brought before this court.
yes, Lordship.
So we will direct that on submission of the charge sheet, registry to procure the TCR in the instant case.
Lordship, in that
Or-
case, Lordship, this petition need to be, Lordship, they have to be, Lordship, amendment to be done, Lordship, because it's only for the quashing of the FIR.
Mm.
So charge sheet submitted, then, Lordship, then the petition need to be, Lordship. They have to be filed additional affidavit for the
To-
quashing of the charge sheet, Lordship.
Correct, that has to be, because you'll have to challenge that.
Yes, Lordship.
On submission of the charge sheet, the petitioner may amend the instant criminal petition, challenging the charge sheet, so filed, if so advised.
Lordship.
List this matter after 3 weeks.
Lordship.
Hmm?
Because the charge sheet, Lordship, we have to, they will submit before the
Trial court.
concern, yes, Lordship,
Hmm.
trial court.
So we'll have to bring this now. Let them file.
Yes, they will bring, Lordship. if
And
they-
let
yes,
them
Lordship.
challenge this trial,
Yes, Lordship.
this, because we will not call for that now.
Yes, Lordship.
If they file it, if they challenge it, then we'll see
Yes, Lordship.
if we need to call for the TCR.
Yes, Lordship.
Let the matter be fixed after 3 weeks.
My lord, there's,
Madam Lordship.
there's an interim order.
Interim order, so
No,
interim
no,
order,
interim already vacated, Lordship.
interim order is not, we have given the leave. But no coercive action can be,
No, Lordship, because no coercive action was till that time when the charge sheet was not
but
filed.
there was no coercive action was there. It's a criminal petition, right?
Yes, Lordship. So, Lordship, now, because it's pending before
have
the
not
court-
been arrested.
Yes, Lordship, not been arrested, Lordship.
You have not been, are you on bail?
No, Lordship,
No, my lord.
there's no bail also, Lordship.
But- But earlier there was.
But they may have, then you'll have to file a separate bail application.
Yes, Lordship, they
On
can,
the, on this
yes,
criminal
Lord.
revision, how the bail can be given? Bail cannot be given and no coercive action also, I don't think that order
yes,
can be.
Lordship.
If you have some apprehension, then you'll have to come up.
They have every, Lordship, chance
Till
to,
now, they have not been, arrested.
yes, Lordship, no arrested, Lordship.
So there is no apprehension, I think.
If they have apprehension, they can,
They can always
Yes,
file a
Lordship.
fresh application.
AB, Lordship, yes, Lordship.
They can always file a fresh application. But they have not filed AB, they have the straightway come for the criminal, with the criminal revision crossing of the FIR. So you don't have any apprehension. That's-
Kindly. Kindly, interim content.
No interim. Interim, why interim? You have not filed any bail application. You have not, you don't have any apprehension. If you would have apprehension, then you would have filed an AB application. You have not filed, so. You have come for crossing. Now charge sheet has been filed. If you think that, if you advise that, okay, I may be arrested, you can come, you can always approach the court. Right?
Much obliged.
Matter number 16.
Your Honor, in this case, I have filed one IA for modification of interim order passed by this honorable court.
You have filed an IA.
Yes, Your Honor. In main case, I'm.
Yes, what happened?
Respondent number.
What
Here,
modification?
Your Honor, that your Lordship may see page number 18 of my IA.
Hmm?
Page 18 of my IA.
Mhm.
This is the interim order passed by this honorable court.
In this honorable court has
Page 18.
page number 18 of IA.
Huh?
Here, Your Honor, in para 7,
Mhm.
in interim, the impugned order that so and so passed by the learned ESC Executive Magistrate Naharlagan and order dated 1906-2026 issued by the learned session court UPSL remains suspended till the next returnable date. As the interim order is passed in the absence of the respondent number 2, the respondent number 2 is at liberty to approach this honorable court for modification and alteration of interim order if so advised. On the basis of this interim order, Your Honor, I have filed this IA. Here, Your Honor, that my humble prayer before this honorable court is that, Your Honor, that the opposite party has begun the construction activities. And earlier that ESC Naharlagan has passed status quo to maintain status quo upon the dispute land. And in main case, Your Honor, that the petitioner has prayed this honorable court that this is the time for this is the right weather time for the construction of the wall. Because of that, he has prayed for the suspension of this order passed by the ESC. Later on, what happened, Your Honor, that the petitioner, criminal petitioner, he has taken advantage to this stay order and began the construction activities, the building construction activity in place of that retaining wall. So, Your Honor, that till final disposal of the main petition, this order that has been passed, where the order has been stayed, maybe Your Honor modified. Where, Your Honor, I have a prayer that the portion of dispute land that may be remain status quo between both the parties.
Interim order was passed when? Passed by the interim impugned orders were passed by the extra assistant commissioner.
Yes, Your Honor.
And extra commissioner
Naharlagan.
and UPA Naharlagun Session Court.
Yes, Your Honor.
In absence of respondent number 2. No, in
No, Your
absence of respondent number 2, right?
Yes, Your Honor.
So what is that order? What is this order passed now?
Your Honor, the brief of the case is that
So the that those orders were suspended. The
Your Honor,
impugned orders were suspended
yes, Your Honor.
by
In
this
main-
court, by a coordinate bench, stating that you have a right to ask for a modification.
Yes, Your Honor.
Now, what happened on this thing, this date? 4/2/2026, notice was issued. So you have received the notice.
My lord, if I may, my lord, we have not received the notice, my lord. Actually, however, my name has been reflected. I am the counsel for the petitioner in the main criminal petition. So I'm appearing today, my lord, but we have not received the notice as of today, my lord. So,
You have not got received that IA copy.
no, my lord,
You have not.
no. My lord.
We have
We have
served you.
checked the
Hmm.
noting, my lord, the service is still awaited, my lord. The service report is still awaited. So, my lord,
Yes, now since you are appearing,
yes, my lord.
so since you are appearing, otherwise also main matter you are appearing, only in the IA only.
That
So
is why,
copy
my-
will be served to you.
yes, my lord. And that was my prayer, my lord, that any order in the IA may be passed after we file our reply. That may be kindly considered.
Okay, heard, Mr.
A voter.
So and so, the learned counsel appearing for the petitioner, appearing for the applicant
In IA.
in the IA, as well as Mr.
Jeetalo, my lord.
G. Talo, the learned counsel, appearing for the appearing for
Respondent number 2 in this IA.
respondent number 2 in the instant IA. Instant IA.
I for respondent number 1, madam.
Also, Mr. T for respondent number 1. The learned counsel appearing for the applicant submits that in terms of the order dated 21/1/2026 passed by a coordinate bench of this court, he has filed the instant IA for modification alteration of the interim order passed on 22/1/2026, whereby the impugn orders dated 28/11/2025 passed by the learned extra assistant commissioner cum executive magistrate, Naharlagun, and 19/9/2026 passed by the learned sessions court, UPR,
Yes, Your Honor.
shall be remain suspended. To be remain suspended. To be remain suspended. Full stop. The learned counsel appearing for his respondent number
2, my lord.
respondent number 2 in the instant IA has submitted that he has not received the notice in the instant case, and no copy of the instant IA has been served upon him. Therefore, he prays for some time and prays that a direction to be passed so that a copy is served upon him. Full stop. In view of the aforesaid, it is directed that the learned counsel appearing for the applicant shall serve a copy of the instant IA to the counsel appearing for respondent number 2. Respondent number 2 today only
Today.
during
Sir. Yes, sir.
during the course of the day. Full stop.
Now I have
The learned counsel appearing for the respondent number 2 prays that he should be allowed sufficient time to file an objection to the instant IA. Prayer is allowed. Let the matter be fixed after 2 weeks
My lord,
on a date to be fixed by registry.
my lord, in the main case, petition, there is interim order, my lord.
In the main application, you write criminal petition number. What was the interim there?
Suspension of the impugn orders, my lord.
No, that has only come for in the modification.
Yes, no, my lord. Actually, my lord, against those two orders,
Two impugn orders.
yes, my lord.
Two impugn orders were suspended by the interim by the coordinate bench, right?
Yes,
So now those were suspended,
yes.
and because those were suspended, you got a suspension order of those
Yes.
these things. Then okay, take it. Till the main petition you write the interim order so passed in the criminal petition number 06. Wide order dated 20, wide order dated, same order,
22/1/26.
22/1/2026 shall be extended in the next date of this date.
Much of.
Item number 17.
Your Lordship. I'm filing IA 56 of 26, paying limitation petition for filing appeal against the impugned judgment and order.
How many days delay?
Your Honor, this is 658 days.
658 days. Okay, heard Mr.
Your Honor, this case was disposed before the MHT Bomdila, and in the particular judgment, Honorable Tribunal has stated that notice was served to me. I am the owner delivery.
Anyways, like that has to be heard. I mean, I will not go into the merit as of say. We'll issue notice on this because there is a huge delay.
The huge delay. On the day of issuing notice, I was just aware of the matter.
Correct,
When
and then those
execution-
things you will argue when the other party appears, the notice is served. Okay, because I mean, notice has to be issued. Your name?
R. Gogoi, Rajiv Gogoi.
Mr. R. Gogoi, the learned counsel, appearing for the applicant. Applicant. No. Heard Mr. R. Gogoi, the learned counsel, appearing for the applicant. Full stop. This is an application under Section 5 of the Limitation Act 1963 for condonation of delay of 368 days in filing the connected appeal. Appeal against what?
order and judgment passed by the Honorable Court of MST, Bomdila. In MST case number 11 of the
Appeal
23.
against the judgment and award dated 7/2/2024 passed by the honorable member, MSCT, West Kameng District, Bomdila in bracket AP in MSC case number 11/2023. Full stop. Issue notice to the respondents. Issue notice to the respondent by speed post as well as usual course within a period of the returnable in 4 weeks. Then you write steps to be taken within a period of 3 days of passing of this order. Let the matter be listed after 4 weeks.
Your Honor.
Item number 18.
What is the other 2 IAs are there?
There's two items. One is stay the operation of execution order.
So no order required in that. You want to move it?
May I, Your Lordship? Your Lordship, I appeared on behalf of Yodeka for the petitioner. Matter is listed for mediation, but the company is not inclining for mediation.
So we'll put it for hearing.
Yes,
We'll post it for hearing
hearing.
because mediation has failed, right?
Yes.
My lord, I'm for respondent appearing on behalf of G Siri.
Heard MS,
Sang SD File.
SD File, the learned counsel appearing for the appellant. Also heard Mr.
W Wangsa,
for
respondent, yes.
Which respondent? How many respondents?
G Siri.
Huh?
Yeah, sole respondent.
Sole appearing for the sole respondent.
Yeah.
Full stop.
Wangsa.
G Sering is also appearing.
I'm on behalf of GC.
G Sering. As per the office note dated 25/9/2025. The instant appeal was sent for mediation. Sent for settlement through mediation. In the mediation center, Guwahati High Court, Itanagar Permanent Bench, Naharlagun. How the matter could not be settled through mediation. Full stop. It is submitted before the bar that the matter is ready for hearing as the parties are duly represented. In view of the aforesaid, let the matter be listed for hearing
After 3 weeks, Your
after
Lordship.
3 weeks.
Right.
Item number 19.
We please, Your Lordship, this matter, I am the respondent, Bajaj Allianz Insurance Company.
Same.
Your Lordship, item number 18 and 19 are analogous matter.
So I mean, the same order will go.
Yes.
Yes.
18 and 19.
Same one.
But
S20, no?
only write his name, huh? Name his name.
Item number 20.
Jimmy. Things will be different, maybe. The case numbers. No, that doesn't. Same order.
Item number 20 also same order.
20 also same order. Yes.
Item number 21.
20 also says appearing.
No, me is appearing.
Huh?
I am appearing.
20 you are appearing for whom?
Yes, or for Bajaj Allianz Insurance Company. Respondent,
You are a respondent.
yes.
Who is appearing for the petitioner?
Prisoner is Mr. Boloram Das. I have not seen him. He is remaining absent today before you.
Okay, you write then none appeared for the appellant when the matter was called for. However, Mr. So is present in the court on behalf of respondent number
Respondent, sole respondent.
so for the sole respondent. He submits that submits that mediation in the instant case. Same mediation failed.
Medicine, yes. The company informed me that they are not inclined to settle the matter through mediation. That's why the matter may be listed on the regular court only for.
No, so there was no mediation happened here.
No, 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 no. Earlier, no medicine.
Mr. So-and-so submits that he has instructions that the company, the respondent is not willing to go for mediation in the instant matter. Therefore, he submits that the matter may be listed for regular hearing.
Yes, but
Full stop. Let the matter be listed after 3 weeks.
of that.
Matter number 21.
None appeared when the matter was called for. Office note dated 5/2/2026 reveals fresh steps for service of notice upon respondent number 1 and 2 is yet to be taken by the appellant. Let the matter be fixed. Let the matter be listed after 2 weeks.
Matter number 22.
Lordship. Lordship, I'm appearing on behalf of T Tang, Lordship, Dr. Tang.
So what is this? You have not taken steps. Mr. So-and-so appears for the appellant and Mr.
Your Lordship, I am from the respondent.
Mr. So-and-so, your name?
K. Moses, Kyoda Moses.
Appears for the respondent. The office note dated 6/2026 reveals that London Counsel for the appellant has not taken the steps for service of notice upon respondent. You are appearing for all respondents.
Yes, also sole respondent now.
You are saying respondent number 2 to 6. Who are 2 to 6? No, there are many respondents. You are for whom?
Rosemary Billa, Your Lordship. Rosemary Billa.
No. Rosemary Barla.
Yes, also.
But there are other applicants also, other respondents also. The respondent number 2 is Kalman Barla, Jumila Barla, then Jennifer Barla, then Ravindra Gogoi, Mamta Sharma.
Your Lordship, I'm appearing on behalf of leading counsel MK Singh, Your Lordship.
Huh?
On behalf of MK Singh, leading counsel.
No, now thing is that if you are appearing, the notice may not be required on you. You are appearing only for respondent number 1, it seems. Okay. He appears for respondent number 1. The office note reveals the service steps for service of notice upon respondent numbers 2 to 6 is yet to be taken. The London Counsel appearing for the applicant. Here it's IA, so right applicant. Applicant is directed to take fresh steps within a period of 3 days. To take fresh steps,
Yes.
let the matter be listed along with the connected appeal after 2 weeks.
Duly obliged.
Item number 3.
My lord, this is appeal against acquittal, my lord. The earlier we have taken leave has been allowed, my lord, and the delay was also condoned, my lord. Now this appeal has to be admitted, my lord. It's an appeal against acquittal, my lord. POCSO method.
Statutory.
Yes, my lord. Since it's prepared by the state, my lord. So state is preparing this appeal, so we have taken leave also, my lord. And now there are total 5 acquitted person, my lord.
So IA has been filed for what?
I am, my lord, initially it was for, my lord, leave from the court for preparing an appeal because this is an state appeal, my lord.
Mhm.
And that was allowed, my lord. And the second one is, my lord, for delay.
So delay has been condoned.
Yes, my lord.
By which order?
My lord, the order is, my lord.
I don't know why the registry put the orders in reverse order here. The latest one should be on the top,
Yes, my lord.
but here it is a reverse way.
And my lord, in main file, my lord, will find the notes noting the some other that noting in the IA, other noting. It's very difficult to find out, my lord. I tried to find out in a serious sequence, but it's not there.
No, that has to be found out now whether this
Yes, my lord.
this has been, though it's a state appeal.
I will find out the date, my lord. There are two interlocutory application. One is 62, another one is 63. 63 was disposed of since it is leave to appeal. It was allowed, my lord. And the second one is 62 of 22.
ಇದು ಕೌನ್ಸಿಲ್ ಆರ್ಡರ್ ಫಿಸಿಕಲ್ ಬಗ್ಗೆ ಡಿವೋರ್ಸ್ ರಿಜಿಸ್ಟರ್ ಆರ್ಡರ್ ಅದಂತೂ ಗೊತ್ತಾಗ್ತಿರಲಿಲ್ಲ ಲಾಸ್ಟ್ ಆರ್ಡರ್ಸ್ ಲಾಸ್ಟ್ ಆರ್ಡರ್ ರಿಪೋರ್ಟ್ ಸಭೆಲ್ಲ ಇದೆ ನಾನು ಅದು ಅಮೌಂಟ್ ಹಾಕ್ತಿದ್ದು So where is the order? I can't look at.
And I'm trying to find out the order, my lord.
To find out, we'll pass it over.
Yes, my lord. Yes.
All for the other matter, Mr. Sharma.
Item number 5 and 6.
The service report is not, not yet come.
Yes.
Or Mr. K. Lolan, you are appearing, somebody is appearing. K. Lolan, learned counsel for the petitioner. And who is, you are appearing?
I'm for state.
Your name, please?
Jitado.
Jitado, the learned APP, na? APP for the state. Office note dated 7/3/2026 reveals that service on respondent number 2 is yet to be completed. Let the matter be listed after 2 weeks.
Lordship, I am for the respondent number 2.
You are appearing for respondent number 2?
Yes, I am filing wakalat now.
No, who is appearing for the respondent number for the petitioner? You come to this side then.
Petitioner.
You are appearing.
Yes, Lordship. On behalf of K. Lolan.
You write so and so, and you write his name. He appears for respondent number 2, who has submitted that he is going to file the wakalatnama today. Let the matter be listed after 2 weeks.
See, also I have already filed affidavit.
Where? In this case,
Yes.
you are filing affidavit.
Yes. They have,
Then wakalatnama, how you are filing wakalatnama now?
I am filing this wakalat number right now.
And you said you have already filed an affidavit.
No, it will be filed today.
It will
He's
be filed.
going to file.
And you write he is filing the wakalatnama today, as well as he is filing an objection in the instant case. Let the matter, instant case today itself, let the matter be listed after 2 weeks.
Lordship, there is an interim order. Lordship.
Interim order so passed earlier shall continue till the next date of listing.
Obliged. Item number 3.
My lord, the delay was condoned on 14/12/25. There is the order, my lord. There was a delay of 190 days, my lord.
You write hard, Mr. T. The learned counsel, learned APP for the state. The instant application and the instant appeal by the state has been filed
Under section 378, my lord, in main.
Is there any IA pending?
No, my lord. All the IAs were disposed of.
Let the matter be listed after 4 weeks.
Yes, my lord. My lord, regarding stay, my lord, 1 week time may be granted, my lord. My lord has given 4 days, my lord, within a week, my lord. Let it be within a week.
Within a week, how?
My lord,
That those persons has to come,
yes, no, my lord. Steps regarding the steps, my lord.
the steps.
Yes, my lord.
Okay, steps are within 7 days.
Yes, my lord.
Within 7
Deeply obliged.
Item number 24.
May I please launch?
Hmm.
This is my lord, criminal appeal Z, where I'm appearing for the appellant and as an amicus curiae. My lord, this is a conviction to the appellant under section 307, read
One
with
second, one
section.
second. Yes.
Convicted under 307, that is attempt to murder. And the Lord, read with section 25 of the Arms Act.
One second.
In Sessions case number 3 of 2000.
Yes, Mr. You are ready?
Yes.
You are ready for the hearing?
Yes. There is nothing much big issue there, only that IO of the concerned case was not examined. And it is settled law that it is not fatal to the prosecution. IO of the case was not examined before the court.
IO is not examined.
Yes. But there is a certain principle of the law that in some circumstances, like instant case, not necessary to examine also. It's not fatal to prosecutions.
You have a case law on that?
Yes, I have a case.
Okay, let us see. Let us see.
Let's fact.
Let him submit.
My argument would be not. First argument is
Now you tell me the facts.
facts. Then may I need your lordship to be record.
on
Now, what is the wrong in the thing?
wrong in the appeal is, my lord, the
Now, where is the impugn order?
impugn order is page 38 to 58.
Passed by
Passed by Sir Lanet
Session Judge
Session Judge
Teju.
Then, my lord, operative portion, lordship may kindly on to page 58. Accused.
Page 58.
Page 58 is the operative, my lord, conviction order. After gone through all the evidence, my lord.
Okay, page 58.
Order.
Okay, okay, read 58, read.
Sri Java Akroya is convicted for the offense he has committed under section 307 IPC and under section 25 of 1B, capital B of Arms Act 1915. The convict is sentenced for 10 years, rigorous imprisonment for committing an offense under section 307 IPC and sentenced for 1 year, rigorous imprisonment for committing an offense under section 25B of Arms Act and fine of ₹1,000 and in default he shall undergo a simple imprisonment of another 1 month. The sentence shall run concurrent. The convict is in judicial custody 26/20/2012 and released on 5/3/2014. Thereafter, he was rearrested again on 7/1/2019 and he is in the custody till the present time in connection with the present case. Thus, the period he has spent in the judicial custody is set off from the sentence award to him. Now, this was passed, my lord.
Yes, this is the, I mean, only part of conviction. You, what are the, how he has come to this conclusion?
My lord, there is an case wherein the Lanet district judge has not properly considering the evidence.
No, you tell me
And
the facts.
only-
You tell me the facts first, then you show me how it was concluded.
First thing is that, my lord, investigation was conducted. In the charge sheet,
Okay, tell me the facts. Where is the FIR?
FIR is, my lord, page 1 of paper book, paper exhibit 1. May I read, my lord? This is 19/6/2012. OCPS Anini. Sir, I would like to inform you that I have lodged FIR against Sri Jaha Ekroya, son of so and so, of a Tallinn, has sought to Sri Murti Nota, Hulu, wife of Sri Chana Mili of Tallinn on 18/6/2012 at that. This is for favor of your kind consider information and immediately action please.
Yes, then
This was registered as Anini.
this was registered by whom? Who?
Registered by the OCPS Anini.
Huh?
OCPS Anini.
No, registered before OCPS Anini by whom? One Sri Boro Ekoya. Boro Ekoya is who?
Boro Ekoya.
I would like to inform that I have lost this FIR against so and so. Who has shot Sri Nuta, wife of so and so.
Against the Java Ekroya, the convict. Now, my lord,
No, Boro Ekoya is who?
Boro Ekroya is the elder brother of this convict. Convict Ekroya,
Acha, elder brother.
elder brother.
Elder brother of the convict.
Convict. This is the story in this, my lord.
Okay, he has filed an
Yes.
FIR saying that he has shot somebody named
Yes.
Nutha, Hulu, wife of so and so. Yes, then
Now then, my lord, after conducted the investigation, during the course of investigation, the IO has drawn the rabies case map of the PO. drawn the rough sketch map of the pier. That is at page 8. Page 8 of the paper.
Page 8 of the paper book. Page 8 is what?
This is the rough sketch match.
Oh no, rough sketch will come later on. Where is the charge sheet? Charge sheet is at page.
Charge sheet is at my lord page.
Page 4.
Page 4. Then of the materials is in page 6. May I read the brief?
Okay, charge sheet has been filed. Brief facts you don't need to require to read. So statements of victims and witnesses as you accused a person by FSA 307, 326 IPC read with 25 1A and 27(1) Arms Act. Correct?
Yes.
Yes. Charge sheet was filed then?
Then my lord, charges frame against the accused. That is not on the record. Yes.
Charge is not there, okay?
Sir. My lord, sir. The charges frame, my lord, that is page 22. Charges frame on 24/12/2013.
24/12/2013.
2013. By
Okay.
Judge, District and Session Judge Teju. Under 326, 307, 25, 1B, Arms Act.
Charge was framed.
Yes.
Page 22.
Yes.
Yes.
Then my lord, trial pay. Now, during the course of trial, only
Deposition, now let's get during the course of trial, yes.
7 prosecution witness examined.
7 prosecution witness. Any eyewitness?
No eyewitness. No single eyewitness.
No eyewitness. Okay.
Yes.
Now let's see the depositions.
Depositions need not PW1.
PW1 is who?
PW1 is the complainant, the brother of the accused.
Page?
Case without 23.
Page 23. Okay, let us see page 23.
There in this deposition, the complainant has failed to prove any case against the accused. Lordship may kindly see page 23.
23, yes.
Accused Jaya Ekroya, this is
My younger brother.
the complainant, have filed the FIR.
Complainant, yes. Then brother of the accused.
Brother of the accused Jaya Ekroya is my younger brother. We are
He is the enemy of the accused or what?
no,
Huh?
not enemy, own brother, own
Huh?
brother.
I mean,
Own brother.
in this Ramayana, there is a story in a Bibhishan that
Well, thank you, Lordship.
yes,
I read my note.
yes.
Same parents. We are from same parents. I am the complainant of the case, present case. I do not remember the time, day, and month of the incident, but incident took place 1 year back. It was told that my brother have assaulted and one Nutapundo, this is victim, on the advice of others. I have lost the FIR copy. I cannot read and write as I am illiterate person. The paper exhibit 1
How old was he? 55 years. Okay.
shown to me might be the FIR copy lost by me and paper exhibit 1A might be my thumb impression. This is not, might be, not mine. I have given my statement to the police. Victim was later on evacuated to Dirugo Hospital for treatment. I do not remember of putting second thumb impression in the case, which is stated to be found in the serial list and marked as paper exhibit 2A. In cross below, the deposition of the evidence of this prosecution was not
Who is PI?
consistent.
PI? Police inspector,
PI, public interpreter,
public interpreter
public interpreter,
in a village.
not in a village, not in a circle, who interpret the executive magistrate with the Gauburas and publics. That is called PI,
Okay.
public interpreter,
He is a government appointed person, right?
government appointed.
PI. Yes, PI and other villagers. So and so.
It is true that I have my lord in cross to this PW1. It is true that I have not seen the incident myself and was told by the PI. Who is PI? PI was not examined in the present case. I have not gone to the Dibrugarh with the victim. I have not seen the injury on the victim. On the suggestion of PI and others, I have lost the paper exhibit 1. I also do not know the region of quarrel. I have lost the FIR to bring the matter to the police authority and law enforcement agency. Victim and accused was not having any enmity prior to the incident. Now, the atmosphere in our area is right.
Okay, then
This is the my lord.
PW then
And PW2, that is place 25.
PW2,
Etra Pulu,
who is he?
elder sister of the victim. Elder sister of the victim.
Eldest son of the victim.
Elder sister of the
Elder sister of the victim. Okay. Elder sister. Yes.
There it. This is small evidence.
I am the.
I know the person is standing on a dog. Santi Pulu is my elder sister. Accused and my sister are neighbor. The distance between their house is 10 to 20 meters. I do not remember exact day and month, but the incident happened in the year 2012. Accused shot my sister by a 12-bore gun by causing injuries on her chest. The victim was first taken to Rohing Hospital and thereafter at Damoni Hospital, Dibrugarh. The cartridges were taken out from the body of my sister. Now this is something point towards the victim, my lord. Now in cross, my lord, there was no any enmity between them before the incident. It is fact that I was not present at the time of the incident and have not seen the incident. It became hearsay, my lord. I have only heard the incident. My victim sister told me the accused had fired from the windows of his house. Fire from windows of his house. My sister did not tell me why she was shot by the accused. The house of accused is SP type. SP, this is SP means semi-permanent type mirror. SP type. The window is general window as used to have in such house. It is not the fact that the accused have not shot the not seen how he fired. She has been told by her sister. Told by her sister on hearsay. Then by now coming to page 27.
Yes, page 27 is what?
PW3. She is the victim.
Victim.
Yes.
Victim survived.
victim survived.
Is in spite of having a bullet in the chest.
That was, my lord, taken out in the hospital. Story.
Yes.
Married, my lord.
Yes.
Small. I know the accused is standing on the top. He is Java Etoya. Accused shot me gun, shot me with gun. When I was standing near my house, he shot me from his house.
Hmm.
The bullet hit on my chest and went out from the backside.
Mhm.
I became unconscious and I gained my conscience only at the way to the Grupo hospital. I was admitted at Damani Hospital at the Grupo. Incident took place on 18 June 2012 at about 9:30 to 10 a.m. I was doing some gardening work in my kitchen garden. I was treated at hospital. A bullet was recovered from my body. This examination in seat. Now, Lordship may come to the cross-examination of the defense. Accused shot me from the windows of his house. That is there in the sheet also. But I have only seen the gun, but not the accused. She have seen the gun only, not the accused. And in sheep, accused shot her from the window. He have not seen the, in cross, it was demolished, my lord. She have seen the gun, not the accused in the room. Other than the accused,
To me, nobody will shoot from his house.
will shot me.
So she is assuming that he must
Yes,
have
she
shot.
only assuming on suspicion.
Mm.
Then Lordship may come to page 29, the evidence of PW4. This is
Dr. Rupjuti.
Doctor give evidence on 19 June 2012, one patient, namely Srimurti so-and-so, lady, is about 35, all come to our hospital with the injury stated to be hit by the bullet. The patient was from Italy, Anini, Arunachal Pradesh. On examination, I found the injury on the right side of the chest of her body. The FG wound was on the front side of the chest, and exit wound in the back side. However, the bullet was struck inside the body, which he taken out from back hole, and the bullet was handed over to the patient and her attendant. Paper exhibit shows the MLC report of the patient and paper exhibit 3A is signature. The paper exhibit report is the information given to the local police of Assam. When this treatment was taken, conducted by him. Now, in cross, my lord, the age of the injury would be less than 48 hours from any my examination, as the blood was still causing from the injury. It was still small peanuts, but I cannot say exact arms using for firing of the step. This is something, my lord. SGL 12-bore gun. Allegation is the accused shoot the victim by the 12-bore gun. SDV. But here the statement in cross given by doctor who have attended the victim says, I cannot say exact arms using for firing of the cell. It was small pellets. It was small pellets. I cannot say the distance from where it was hit to cause the injury. This is the, my lord. Then, my lord, third last. PW5, that is page 31. What happened to Ekru? They have not given any incriminating evidence against the accused. I know accused Java Akroya before expiry of my father, I was told that this gun was given to accused Java.
Before expiry
Before
of my father, I was
of my
told that
father, he
his
was
gun
told that
was given to accused Jaha
gun
Ekroy.
was given to
Okay, his father's gun was given to him.
given to Java. In cross, Lordship Mecca, it is true that I have stated before the police that I do not know the accused
Jaha
Jaha
Ekroy.
Ekroy. He gave a statement, we do not know the accused. I do not have any documents to show that the gun belongs to my father. Nor I was told any number of gun. I cannot identify the gun of my father. This ship and the cross, my lord, here, what evidence is given to the accused is not clear. Whether gun, he says in ship that my father's gun was given to accused. But what gun was given to the accused, he cannot see. He cannot read the number of the gun also.
Yes.
This is in the cross, it was demolished. And my lord, page 33, PW6. Episode Ekroya, S40.
Page 33.
Page 33, Lord. This is PW6. He gave evidence. I know the accused person, Java Ekroya, who is absent today. He was not there. I have no idea from whom the police had seized the gun. I have not put thumb impression on any citizenship. This is against the prosecution case method. Who happened to
The Caesar witness, he said that
yes,
he has not put.
yes. The position drafted by you. No.
Okay.
Victim decline, cross examination. Now, PW7 is the magistrate who have recorded the 161 statement of the accused. I identify the standing on the door. He is Java Ekroya. I was the magistrate who recorded the statement of the accused on 27/6/2012. The accused was informed all the formalities before recording of his statement. The accused confessed before me that he shot fire at the victim, Santi Midi, while he was drunk in his statement recorded under section 164 CRPC, paper exhibit 5 containing 5 pages, is the confessional statement, and 5A and 5B are my semester. This is the statement confessed before the magistrate.
So it is on the basis of confessional statement he was convicted.
Yes. The learned magistrate, the district and session judge, my argument would be that only based on this confessional statement, conviction under section 307 and 25 IP has been convicted. Otherwise, in the prosecution witnesses, no one has proved the case against the act.
But this confessional statement is a judicial confessional statement.
My lord, this confession under recorded 164.
No, is an admissible piece of evidence.
Procedure
No, it's a admissible piece of evidence. First of all, it's a judicial confession. It's not an extrajudicial confession.
Yeah.
So how it used to be weighed, that has to be seen.
Yes, that
with the other
that can be used not an evidence, but it can be used as corroboration of the evidence given in the court or by the prosecution witnesses and defense witnesses. That is the law.
They will have to show me the law.
Then, my lord, that I'm coming, my lord. Then, my lord, 313 question. examination was put to the accused after closing of the prosecution.
Yes, 313, please.
That is below 35. The question which was not required to be put has been putting to the present accused, convicted accused. Here question number 1 itself is wrongly put to the present appellant. Lordship may kindly see. Question number 1. That PW1 Sri Boro Ekroya has deposed that he was told that his brother has been assaulted by you. Assaulted by you, for which he has not appeared. What do you have to say? In the deposition of PW1,
There was no statement like this.
no statement like his brother was not assaulted by the accused. This is something carelessness on the part of.
But he admitted also. I do admit that I assaulted his brother. I may be allowed to confess and may accordingly be convicted and sentenced. I do not know how and why assaulted him. I am stating in sound mind and voluntarily. What is this?
Because my lord, proper question was not sought to the accused for explanation. The question which was sought to the accused at the 330 examination is from other sources. Therefore, this answer, question and answer is wrong, which is not brought on record.
Okay, go carry on.
So, my lord, then other question. Depose, PW2 depose. Sri Irta Pudu deposed that his sister has been shot by a 12-bore gun by you. What do you have to say on this? This is all right. I have compensated the victim for causing injuries on her by gunshot. Now, questions and answer is so different. And question number 3, Santi Pulu deposed that you assaulted her. What do you have to say? This is true. I shot at her because I got annoyed with when she dumped garbage in my place. And question number 4 is MO, medical officer, has exhibited the medical report. What do you have to say? I have no idea. That is all right. Do you have anything more to say in regards to this case? Even if I say more, that will not be helpful. That is the so 313, though it has put some questions, but then by not 313 is also a procedural law, not read as an evidence against the court. That is not there. So this is the all about my lord evidence. But then, my lord, my submission is that their allegation is gun was shot to victim. And in charge sheet, they says that the empty cartridge of the SBBL 12-bore gun was seized, and it was sent for a special examination. But this special examination was not brought in record, and it has never been admitted, and it was not been established whether it was used by the accused from the gun, from the gun, and is to be used in this. And secondly, my lord, during the course of trial, the SDVL got 12 more, which was said to be uh,
Used for the same.
used for the incident, was seized from PHE, Public PHE, Public Health Center.
Custodial gun was recovered from?
It is in this, it is said that it is seized from the PHE. PHC from the possession of the accused. But then seizure witness,
PHE
PHC
from the position of
from
accused.
the possession of it. PHC means not from the house of the accused, where the incident took place. PHC means primary health center. From which primary health center it was recovered, it was not disclosed.
Hmm.
Then, my lord, seizure witness, PW 6 or PW 5, it is not supported. The prosecution witness that prosecution case that it was seized from the possession of the act, or from where it was seized, it was not established. Then thirdly, my lord, my submission would be that the IO of the case, investigation officer of the case, was never been examined in the course of trial. For not examination of the investigation officer of the case, my lord, the search sheet which police has filed before the direct CGM
There is no proof.
was not exhibited and proved. Seizure memo, not exhibited and proved. Rabies case mess, not exhibited and proved. There is a defection in the course of trial.
Yes.
Therefore, my lord, it required proper proof. Only on the case of suspicion, serious suspicion also, in need of requirement of the proper proof, the court should have not been convicted the accused for imprisonment for the period of.
Let us see what is the reasoning of the court
My lord,
in the judgment.
my lord, I have not that much prepared the,
Hmm?
but I have one case.
No,
for
no,
your
no.
lordship.
Judgment mean I'm talking about the impugned judgment in order. Impugned.
Impugned judgment.
What has been discussed? Let's see how he has convicted.
In the entire, my lord, discussion in the judgment, what
Hmm.
I have gone through, my lord,
Hmm.
it is accused has confessed before the magistrate. He was drunken in mood and without knowing the consequences of the case, and that 164 statement of the accused and 313 examination, there is a corroboration, consistency. Based on that only, accused can be convicted under 307. That is in the judgment I have gone through. And ML, considering with the MLC. MLC, we have no any.
Hmm?
In considering the MLC, we have no any dispute with
Considering the
MLC, medical
okay.
report.
Hmm.
That is already there in the report. But my lord, my submission is there is not true beyond reasonable doubt. And my lord, I'm going to conclude my submission. Then
You got any case
my lord,
laws? You got any case laws? That IO non-examination of IO, non-proving of the seizure list and charge sheet are fatal.
yes,
You have any case laws on this?
yes. Then my lord, may I inform the honorable court,
Hmm?
lordship, that after conviction and during the course of trial and after conviction, this is the sentence for 10 years.
Hmm?
During the course of trial and after the conviction was recorded for sentence for 10 years, this appellant accused has already suffered inside the bar. As on today for more than 8 years, 4 months, 20 days now. As on today. He was arrested on 19. 19/12/2012. Now, thereafter, he was in bail for some time. Then bail was granted by wrongly granted by the magistrate after committed the case before the learned session judge. That's why it was cancelled, and then bail was cancelled, and he was taken back in custody. And as on today, and conviction was recorded on 20/12/2021. After conviction, 4 years. Before conviction, 4 years. My lord. Total 8 years, 4 months,
20 days.
20 days.
You have any case law on the point of non-examination of the IO?
That part, my lord, I have not brought. But then here I have one case law reported of GLT.
What is the case law?
Case law says, my lord, there may be a suspicion, serious suspicion, but then serious suspicion cannot be replaced. My lord, suspicion, how strong it may, cannot be replaced the requirement of proof. In this principle, my lord.
What is the case?
Case is that, my lord, this is GLT.
You have a copy of case?
Yes, my lord.
Give it.
Radha Mohan Hajam versus State of Assam.
Which paragraph?
Para 27. This is the difference from Honorable Supreme Court. From Honorable Supreme Court.
Difference?
Taken difference from Honorable.
Or taken reference, okay.
Reported with 2000.
Para 27, yes, Sujit Biswas.
Yes. Yeah, on the suspicion, it cannot be placed apart. Therefore, I have shown lordship that everything whichever was conducted investigation, anything was not put before the time. So, no. May I pray that Honorable Court may interfere and set aside the impugn order passed on 20/12/2014. That would be my lord limited argument and my submission and my prayer.
Yes, Mr. PP.
Your Lordship, I'd like to begin with this contention that with this judgment is well justified and well reasoned. This judgment is well justified and well reasoned, which is sufficient to convict the present appellant. Why? Because, Your Lordships, fact learned amicus curiae has narrated thoroughly. I have been on the law point. 164 is there. 164 confessional statement is there by the accused before magistrate without endorsing any threat or using any force. voluntarily confession is there. Secondly, that confession statement was corroborated and consistent with 313 statement of the accused. May I take your lordship back to 313 again?
Yes.
It's in page
Page 35.
35 years. Here, second question is very important. That the PW2, Sri Erita Pulu, deposed that his sister has been shot by 12-bore gun by you. What do you have to say on this? I have compensated for the victim for causing injuries on her by my gun. He admitted again in 313. And evidence value, and third question, Your Lordship, next page. Next page. Third questions, that the PW3 some people deposed that you assaulted her. What do you have to say on this? Answer, that is true. I shot at her because I got annoyed with when she dumped garage in my place. Your motive is clear. He shot her because he was annoyed when this victim dumped garbage in his place, in accused place. That is a motive behind the events of shootings. And Your Lordship, though there may be no eyewitnesses, but circumstantial evidence, it clearly points out against the present appellant. MLC support the contention of victim that some bullet injury was hit on her chest and it was removed by the attending doctor. That is MLC report.
Where is their FSL report?
MLC report, that is in page 10. FSL is not there.
Then how do you know that that gun? I mean, that was the gun whereby this shot was made. Is it so easy in murder cases or attempted murder cases?
But fact shows that
prosecution did not bother to bring in that FSL report. It's so important, especially in a case where gun is involved. You'll have to prove that that bullet was shot from that gun. Have you done so?
it is not there in the record. But circumstances what says, doctor instantly on that point of time, it was recorded. Immediately, victim rushed to the hospital.
And the bullets found there, those are very small pellets.
Yes, this SBL gun is actually used by the cartouche where multiple pellets were there inside. And it's, when it's fired, it's sprayed, not a single bullet. And so that's why other bullet may go exit from the body, and there is exit one also in the MLC report. But one small pellet remains inside the body. That was taken out. MLC report may kindly peruse.
Where page?
MLC, it is in page 10 and 11.
Page 10 and 11. What is report? What report is this?
This is MLC report. The last para. I would like to inform you that the bullet recovered from the chest of the patients on 19/6/12.
Handed over to so and so, so and so.
Yes.
Then
that means so he was so it is proven fact. It is proven fact. And by whom it was sought by was corroborated by the statement of PW3, who is a victim, who clearly point out the accused person on the dock, and the 164 of the statement, and the 313 of the accused. These are all consistent. So some minor discrepancy may happen in criminal cases, but that should not be a ground for acquittal only. We have what criminal jurisprudence say, to see the both, not injustice should be happen to the accused, nor injustice happen to the victim also.
But 313 statements, I mean the questions that those have been put, only few questions put,
Yes,
only few questions.
but
And those are also, those are also not in the line of the depositions made.
actually, Your Lordship, 313 has two aspects. One is for corroboration, and one is for giving opportunity to the accused to explain on the incriminating questions. To explain, yes, I did not, and what actually happened. But he clearly admits that he shot her by gun because on
He was not given much opportunity, because there were some certain statements of the sister saying that she doesn't know, she did not see. All those questions were not put on him. And if those questions would have been put on him, then he would have got an opportunity to probably say something. But those opportunities were not given to him. See, the minimum question you ask, that means you're curtailing the opportunity to defend by him.
Actually, here in this case, Your Lord,
If you only put one question saying that whether you have committed this crime or not, and he may say, yes, I have committed the crime. But whereas there are so many other aspects in the deposition, those questions are not put.
yes,
So he didn't get an opportunity to defend, and he didn't get an opportunity to explain or defend.
there is a limited prosecution witness, altogether 7 in number.
7 quitters.
Yes,
Yeah, and
most of them are hearsay evidence. I do admit it.
correct. So here,
Yes, in regard to the examination doctor, he has no idea.
as far as the depositions of the hearsay evidence also, whether any questions were put. Questions were not put.
Yes,
This 3-1.
question 1 is regarding FIR.
Huh?
Question number 1 is regarding FIR.
Correct. Question 1 is FIR, and question 2, question 3. How many questions? 5 questions put.
5,
altogether.
yes.
4 or 5 questions altogether. Right.
1, 2,
Now, what is the law on the 313 questions statements?
313, Your Lordship.
What are the questions that should be put by a court? Only to, if you think that like the purpose of 313 is only to somehow bring out one answer which he will admit and convict him. That is not the purpose.
No, it is not.
That is not the purpose.
It is
Then
not only
why-
purpose.
why-
313
then
is
why-
giving opportunity.
Correct. Then why other questions were not put in? Only 5 questions, and that too, very straightforward questions, and one question was totally wrong. The first question, that which has been put, Sri Baraba Akuriya
Yes.
has deposed that he was told that his brother has been assaulted by you, for which he has lodged an FIR. What do you have to say?
Here relevant question is 2 and 3. And 4 is upon MO who conducted MLC, medical examinations. And court is giving an opportunity. Do you have any more to say in this regard in the case? He has been given opportunity. Oh, sorry, fifth one. Even if I say more, that will not be helpful. But he do admit that he compensated for his shooting incident. In clear terms, he admitted.
He stated that I have compensated victim for causing injuries on her by gunshot. But he didn't say that like the gunshot shot by me.
Yes, on her by gunshot.
That
On her by
PW
gunshot.
deposed that his sister has been shot by a 12-bore gun by you. What do you have to say on this? He stated that I have compensated the victim for causing injuries on her by gunshot. Gunshot by whom? He.
Yes, he injured the victim by his gunshot.
Who said so?
Here, 3-1 is on a victim to.
Yeah, correct. Now, see, I mean, the question was that PW2 Sri Edita Pulu deposed that his sister has been shot by bore gun by you.
You.
Correct. What do you have to say on this? Now, whether he has admitted that I have shot the gun.
Yes,
and after shooting her, I have compensated her. Whether he stated like that, he didn't say like that. He says that I have compensated the victim for causing injuries on her by gunshot. And who has made the gunshot? He didn't admit to that. He said that I have compensated. There's a villager, somebody is shot by somebody. Okay, I have some money, I compensated her. I paid her to do something. I mean, it may not be rightly worded. It can be presumed like that also.
If he did not made any mistake, why should he compensate? And
Correct.
he admitted that
in a village,
I'm compensating for gunshot upon her.
In a village, if in a village, if there are people who has been injured or shot, then some other people can also compensate. Compensate means, I mean, it may not be properly
And
worded.
this question number 2 is followed by question number 3. Next page. That PW3, some people who is a victim, deposed that you assaulted her. What do you have to say on this? This is true. I shoot at her because I got annoyed with when she dumped garbage in my place. It is true. He admitted. And it is consistent with the statement given and confidential statement under 164. And same, these two sections, 313 and 164, was corroborated by the deposition of victim PW3. All are inconsistent. And medical examination report, that is MLC, also supported the contention of PW3 that he was shot by gun and some pellet was extracted from her body. And SPL gun is not like one bullet.
But your charge sheet is not proved. Your seizure list is not proved.
Seizure list is proved.
Then how you even
seizure list is exhibited.
Who has proved it?
It is exhibited
One
by
person that seizure witness has denied it.
No, witness exhibited
Yes, seizure witness has denied it. And PO, I mean, your investigating officer did not come to prove it. Then on what basis you are saying that you have made the seizure?
Seizure list is already yourself exhibited by.
Exhibited, but exhibited, whether only exhibiting will do. That document, you did not prove it. Who is going to prove it? Seizure list. If you do not prove the document, what is the validity of that document? Evidentiary value? See, I submit lot many documents before the court as an exhibit, but I do not prove it, the contents of it, whether it will be termed as proof. The document has to be proved, contents have to be proved by the person who has done it. The IO has done it. He has prepared the seizure list. He has filed the seizure list. Sorry, the charge sheet. He hasn't come. The Caesar list, he has prepared the Caesar list. Caesar witness said, no, I have not put the signature. Then the person who has made the Caesar list, he hasn't come to prove the Caesar list. Then what remains in the prosecution case? Only on the basis of 313 and that supposedly made confessional statement, whether a person can be convicted, and I mean, whether this in this case, you can say that this is beyond reasonable doubt, and circumstances complete the
Yes, when
only on the basis of his one confessional statement he has made. Then a confessional statement is always a very loose kind of evidence. It has to be properly corroborated. Though it has a value, but it has to be corroborated by many circumstances.
in some cases,
And secondly, 313 statements. 313 statements on the basis of 313 statement and on the basis of the confessional statement.
compensation, this confessional statement can
But you said that like if IO is not examined also, it is not fatal. If you have any case law on that.
Yes. On that point, I'm submitting some.
You take your time, just take your time and give it to me.
Just 2 pages.
Yes.
Next page, page 2, second para.
Second para.
Yes, page 2, second para. May I read?
Yes, yes.
The appellant has not been able to check the credibility of eyewitnesses. No material contradictions in the case of the prosecution has been shown to us. Under this check and circumstances, the non-examination of investigation officer as a witness is of no consequence. It has not been shown what prejudice has been caused to the appellant by such non-examinations. Prosecution has given opportunity, and he doesn't adduce any evidence defense witness also. Defense doesn't adduce any.
Here, the appellant has not been able to shake the credibility of the eyewitnesses.
Yes,
see, eyewitnesses and circumstantial evidence is totally different.
Here, this is a judgment of 1996.
Yes.
Page 9. Second last page.
1 second. Yes. Page
9.
Para.
Last para.
Para 9.
Page 9, last para.
Achha, page 9. Paragraph.
Paragraph is a.
Okay, page 9.
It's not specified, but
there is no para. So where you have printed this?
No, para is there. Para 50. Para 50. And there is no sub.
Oh, India Canon you have taken. India Canon to.
I will here in front page. I have made some remark that where this is equivalent judgment of the reported in 1996 SCC 2317, and thereafter in All India AIR also.
Correct. What like thing is that I mean, if paragraphs are not there, how is to be referred?
The paragraph is there 50. Within 50, it is there in last para.
And last read.
May I read? It, however, appears to us that the entire case diary should not have been allowed to be exhibited by the learned additional session judge. In the fact of the case, it appears to us that the involvement of the accused in committing the murder has been clearly established by the evidence of eyewitnesses. Such evidence are in conformity with the case made out in FIR and also with the medical evidence. Hence, for the non-examination investigation officer, the prosecution case should not fail. We may also indicate here that it will not be correct to contend that if an investigation officer is not examined in a case, such case would fail on the ground that the accused were deprived of opportunity to effectively cross-examine the witnesses for the prosecution and to bring out, next page, contradictions in the statement before the police. A case prejudice likely to be suffered by an accused must depend on the fact of the case, and no universal straightforward jacket furnished formula should be laid down that non-examination of IO perceive with a criminal trial. And here is the here's the little explanation printed from net that when it is fatal, when it is not fatal.
And yeah, we are to be all this. I mean, artificial intelligence or what?
Yes, but it is just only for reference, not
No, I
for
mean-
not for record.
Don't place all this.
It was categorized. What role
This
has
is not
for-
authority. I mean, you cannot place.
No, it is not authority, I do admit, but just only for reference. But here in non-fatal case, when it is not fatal, and when it is fatal when there is, second point, if the defense is denied by opportunity to cross-examine on BTF issue, such as severe contradictions, delays in recording statement, or improper handling of the evidence.
In both these cases, but the fact is that there were eyewitnesses. No, one
Seven
one thing is true that non-examination of IO, how
Yes.
you have been how you have been prejudiced.
Yes.
See, in this case, what has happened is that IO has prepared the seizure list. IO has prepared the seized all. IO has made the seizure list. So seizure list, whatever seizure list has been made. So whether the gun was seized from whom, whether whether the official report has come, whether it has been proved that like that was shot from the same gun. All these things, he didn't get an opportunity.
No, all the prosecution witness out of 7, they all were examined. All 7 were examined, but only one become hostile. That he has no any idea. Otherwise, rest other witnesses corroborate with each other.
How?
They
One person is saying it's all saying that she heard from somebody. Correct. And
Yes.
nobody has seen it. Now,
no eyewitness.
yeah,
Yes,
no
yes, that's true.
eyewitnesses. Now, thing is that I mean, if the seizures have been made, now there is an allegation that gun which has been used, that has been seized from him from PHE. Correct. Now, if IO doesn't come, then whom he is going to ask? And who made this statement? Who made this statement that it has been seized from PHE? The seizure witness.
No one stated, but that it is seen in the seizure list.
Hmm?
Seizure document.
Seizure list, if seizure list is there, then I mean, seizure list is prepared by him, but seizure witness is there. He could have been cross-examined. He could have been cross-examined, isn't it?
This is place of seizure, that is place 9.
Yes. So
Place of seizure, AC Tadin POPS annually district Divang the DAP. on 26/2012.
So there are two Caesar witnesses, Baro Akio and Episo Akroya. These witnesses are there. And they will be present before the court, and they could have been cross-examined.
Acroya says whether that was his or not, I have no idea. That's this. Another episode says that I have not seen the police have come and seized this, material from the place of.
So basically, his case is only on the basis of 313 statement, as well as the and 164 and
MLC.
and her medical report is to a certain extent that it was made by a gunshot, but like it hasn't been proved that like it was made from the same gun. FSL report doesn't come. You haven't produced the FSL report.
And yes, 313 and 164. That is, I have
This one, okay.
citation letters reported in 1998.
1993,
Yes,
criminal law journal, na?
yes, Guwahati High Court.
I could also. Okay, which paragraph?
Para 2.
Yes, you read.
Just for concept of the 164 and 313.
Yes, yes.
There is no direct evidence. Prosecution relies on confession recorded under section 164 CRPC, extrajudicial confessions, and other circumstances. Other circumstances. Extrajudicial is not there, but confession and other circumstances is there. Then second, fourth, para 4, from the
In his examination.
from the middle of the line, yes, from the middle of the para. It is,
He read the whole para, na, in his examination.
in the examination under 313 CRPC, the accused stated that he had
Committed no
committed
crime.
no crime. Such and such person had a dao in his hand, and he made an attempt to cut him. The accused matched the dao from such and such person and brandished the dao at him, and in the process, some person was injured. He had not committed any crime nor injured that person intentionally. Accused admit that he made a confession before the magistrate. It is settled that answer given by the accused in the course of examination under 313 are not evidence, but they may be taken into consideration both for and against the accused. That is, his statement can be taken into consideration in judging his innocence or guilt. So when 164 and 313 are taken together and they are consistent with each other, that could be a main factor for convicting to held guilty or not guilty. Their opportunity was sufficiently provided to him. His counsel already examined all the witnesses, cross-examined. Yes, of course, there is, for IO, I have submitted some citations. And 313 is already in record. For this 164 constitution is already there.
Okay, then now you show me that where these things has been discussed by the learned trial court. How it has been discussed by the learned trial court.
In this case,
Yes. Like this judgment, you have any more judgments?
no, impugned judgment.
No. You have any more judicial?
No, that much only.
That much, huh? And like impugned judgment, you show me how he has handled this. The learned trial court. So discussion comes from page 48. Okay.
Yes, discussion from port 48 and relevant pages para 15.
Para 15. Okay.
issue frame was that in 14, page 12, there are 12. After hearing the counsel and after having gone through the provision of law under which section the accused is said to have committed the offense, the court has decided to find out mainly given below points along with other points if we needed. First, if the gunshot was shot at the victim by the accused or not. Second, the court thereafter in second point will decide whether the accused had the intention and knowledge that his act, if acted upon, would cause the death of the victim or not. Thirdly, the court will decide whether accused can get the benefit under section 85 of IPC or not. Fourthly, this court will decide if the accused has committed an offense under section 25 1B of Arms Act or not. Then detailed discussion is begins from para 15.
FIR, then you can skip this.
It's a long discussion. And what
He has convinced himself in 2 paragraphs, right? Then he has gone to section 85.
Eighty-five is act of a person incapable of judgment by reason intoxication caused against his will. Well, against his will, but his statement is that he was intoxicated, but it was not intoxicated by some and section 307, attempt to murder.
Where is this confessional statement?
Confessional is at page number 14 to 17. And statement is at page 16. May I read yours?
When was the FIR file? FIR file on
FIR on 19/6/2012. And final conviction was done final conviction was done on yes, date of judgment of conviction was on 2012-2021.
Yes.
Yes, Your Lordship. 307 attempt to murder.
Hmm?
307 attempt to murder.
Hmm.
I'd like to point out only the illustration point.
Hmm? You want to point out what?
Illustration point
Hmm.
in the section. Yes, in section 307, illustration C, it is written.
1 second. IPC.
What? Last question.
Yes.
Illustration
C. Illustration C. Yes.
A, intending to murder Z, buys a gun and loads it. A has not yet committed the offense. A fired the gun at Z. He has committed the offense defined in the section. And if by such firing he wounds Z, he is liable to the punishment provided by the latter part of the first paragraph of this section, which is attempt to murder. And if it succeeds, that means it becomes murder. And Your Lordship, here in 164, he clearly says, though he was intoxicated, but he was so much annoyed that he put out his already loaded gun.
But he said that he is not sure whether it was already loaded or not loaded.
Yes, but if gun happened to fire, that it was loaded. And he also admit that on earlier occasion he went out for bird shooting. And thereafter, gun was kept.
Hmm?
Prior to the incident, he was gone out for the bird shooting.
Ah,
Just
yes,
acting, and thereafter, this incident happened. That means gun was already loaded.
Bird shooting, I mean, the same gun is used.
He only says like that.
No, usually
Contest like that.
usually bird shooting though you use this
Generally,
air gun, na?
not air gun, in SBL also.
Huh?
SBL gun also. Here, which was shot by the.
This is used in bird shooting
it is
also.
used.
Not the air gun.
No, air gun has only single blade.
Bullet
But this gun has SBL gun has some multiple but coming up when it's fired and it's sprayed. There is little chance of missing the target. That's all your rules. And London amicus curiae is there to help us.
Yes.
I'm representing the victim, Your Lordship, in this case. I mean, in fact, I'm the legal aid counsel for the victim.
Yes,
I've been appointed as the legal aid counsel. Just adding some of the points. Just I'll be reiterating what my learned PP has submitted, except 1 or 2 points here and there, Your Lordship. Now, my submission would be, Lordship, as my learned PP has also submitted that the one of the most compelling evidence in this particular case for convicting the alleged accused is the 164 statement, Lordship. Now, Lordship, here we have to see that 164 statement which was recorded by the magistrate, whether it was recorded that voluntariness is the paramount here, Lordship. Now, Lordship will see that in order to establish that that 164 statement was voluntarily taken, Lordship, the magistrate was also examined as prosecution witness number 7. Lordship will find that at page 34 of the paper book, Lordship.
And she has given a certificate also.
Correct, Lordship. Now here, if we see the statement given by the magistrate, all the probabilities that is required for registering a 164 statement has all been complied with, Lordship. There is no at all a room of doubt creating where the 164 statement, while the 164 statement was recorded, Lordship. Now coming to the content of the confession, Lordship,
Now, Lordship will see that the content of the Lordship may have read also, Lordship, page 16, Lordship. Now, content of the statement, Lordship will see that it's very apparent and it's very clear that, see, he is the one who has committed the crime. It clearly says, in the morning of 18/06/2012, I was heavily drunken from my place. When I returned to my house, I saw that my veranda porch was deposited with large number of timber and wood. I was thinking and annoyed, and those people, especially Srimati Santi or Nuta, always disturb me. So I started some of the words from my veranda. Thereafter, in angry mood, and due to the drunkenness, I took out my gun and shot at Srimati Santi Mili. Due to the drunkenness, it is not clear that whether I have loaded the ammunition bullet in the same morning or the previous day. I went for bird shooting. Worship, here, the confession that has been made, it's very apparent and it's very clear that he is the one who has committed the crime. Now, the learned court below, Lordship, has rightly relied upon the statement since it is given voluntarily, Lordship. Now, apart from this 164 statement, corroborating this 164 statement, Lordship will also find that the victim's statement, Lordship will find at page 7 of the paper book, Lordship. Now here, the victim, I know the accused is standing on the dock. He is Jaya Kroya. Accused shot me gun when I was standing near my house. He shot me from his house. The bullet hit on my chest and went out from the backside. I become unconscious and I gained my consciousness only at Ghat way to Dibrugarh Hospital. I was admitted at Damini Hospital at Dibrugarh. Incident took place on so-and-so. I was doing some gardening work in my kitchen garden. I was treated at the hospital. A bullet was recovered from my body. Now, this very 164 statement is also been corroborated by the unwavering testimony of the victim. That also may be recorded. Now, coming to the medical evidence, Lordship, the doctor who was examined as PW4, Lordship. This is also a corroborating material for the confessional statement, Lordship, which supports the confessional statement. Now, PW4 is the Dr. Roop Jyoti Datta. Now, in his
That we have seen.
Lordship.
You come to the sketch map. Sketch map.
Eight, yes.
So it was supposedly shot from the window
Window
of the house of the accused.
10 to 20 meters distance only, very near.
No, I mean, where is this? I mean, in the rough sketch map, the accused house is D.
Correct, Lordship.
Then victim standing. I don't know how this rough sketch.
This is of course it is this sketch map is also not properly drawn.
There was a road to Italin. There was a river other side.
Just on the back side of the accused house.
But the shoot from accused fire from window. Window is there. It's not very clear. Anyways, I mean, do you have anything more to add?
Lordship, what point that has to be seen is, Lordship,
Mm.
that accused person,
Mm.
he was the only one person who was available in the place of that accused house. He was the only one.
From where
person.
you're saying so? Is there any material that he was the only person around?
Now, from the statement of the victim,
Statement of the victim. Victim says so. What?
Other than him,
Mm.
there won't be, and then the statement of the accused under a 164 statement, it becomes apparent that he was the only one person who was there in his house.
Yes. Because the accused stays alone. His wife already expired.
Correct.
So he was the only person, he was the only person at home
Yes.
who possibly can shoot.
Correct.
That is why the victim said that other than accused, to me, nobody will shoot from his house.
Correct.
Mr. Learned Counsel is now smiling. He will give a reply. Mhm.
Now, another point is, Lordship, the ownership of the gun, Lordship.
Mm.
Uh,
That hasn't been proved.
Lordship, PW5 has clearly stated that gun was his father's gun, was handed over to him. That's there in PW5's statement, Lordship, the position, page 31. Now, from this statement, clearly goes to show that
No.
firearm was
See,
being held.
problem is that FSL did not come.
Correct. That is.
The only thing that I mean, your case is only on the basis of
160.
this 164 confessional statement
31.
before the magistrate, as well as this 313 statement, which you are saying that he has admitted. Correct? Other than that, there are loose ends. But now thing is that whether that much is sufficient to convict a person.
Lordship, in my considered opinion, Lordship.
IO hasn't been examined.
Correct, Lordship. That
So
is.
seizure things, I mean, seizure list is not proved.
No.
So whether the gun was actually seized from him, that fact hasn't come out beyond reasonable doubt. But yes, 164 and 313 in circumstances may be sufficient to convict one person.
The way the crime was committed, Lordship, other than him, no one is, Lordship has also rightly pointed out. There was no other person other than him in the house. So firearms coming from there, Lordship, hitting the victim, and voluntarily statement given by him that he has committed the crime. So I think this is sufficient to convict him, Lordship. Now 307, Lordship, I think it is proven beyond reasonable doubt.
That is
The
not
weapon that was used.
as far as
intention.
ingredients are concerned, that is not a doubt. If he has fired it,
Yes.
then that is an attempt of murder. Murder means, I mean, it may not, I mean, he had the knowledge that if the bullet is shot, then the person may be killed. That
Also,
much of knowledge he needs to have. Now he is taking, you're saying that he was drunk. But drunkenness doesn't
yes, that
take away,
plea he cannot take.
it cannot take away his.
Section 95, which is plea that he has taken.
Yes, you have anything to reply? Mr. Counsel?
From my side, I have nothing to make reply.
No, see, I mean, see, they have raised they are asserting that 313 and 164 corroborates, and there's nothing more required. Why IO is required? Now, what IO is going to do in this case? Because he has already admitted of commission of the murder, and how he is going to, if the IO comes before the court, how it will help this accused to defend his case on the face of the statements he has made before the magistrate as well as before the court under 313.
That is, my lord, as per procedure. When any materials, incriminate materials, brought in court, firstly, it should be proved by a person who has collected that materials from the possession of any source. And procedure says that who have collected that particular materials or documents, person they used to put their signature. And when whether my question would be that seizure was actually prepared by the concerned investigation officer or not. That was not proved in the case. Then,
but like, I mean,
why that official report, official examination, it was so down to the
in cases where there was no confession before magistrate, or there was no admission of his guilt under 313, then those things would have been very material. But in the instant case, I mean, already he has stated all these things, and other circumstances also pinpoint him. So in those cases, whether in absence of those, whether the case will be, the prosecution case will be fatal, prosecution case will be totally brushed out.
My lord.
Lordship, I'll just take your leave, Lordship. I have a matter at
164 statement of the accused is an evidence, but not used an evidence. This is simply a procedural law matter. Therefore,
But confessional statement made before a magistrate under 164.
Now, this can be used for corroboration.
So corroboration
Evidence lead by the prosecution.
corroboration is 313.
Now, 313 is a statement made by accused himself.
Yes.
164 statement is made by accused himself. That accused person cannot be the witness of his own court.
But there are other witnesses who is saying that he has done it.
That
it's not only him.
No corroboration, consistency on that other witnesses, my lord, prosecution witnesses. Therefore, my lord, victim also says that he shot, but then who shot her? He was.
But
her evidence was has
he
been
said like he must be the person. So circumstances what?
Only she deposed. She have seen the gun.
She has
have
seen
not
the
seen the
gun,
person.
Not seen the person.
Yes.
But she said then later on she said that it must have been him only, because and other circumstances if you see, that house is owned by him. That is not denied.
That part, my lord, we
another indisputed fact is that his wife is not there. They are not there. She died. They do not have children. So he is the only person who resides in the house. Those are circumstances, correct? Those are the circumstances you need to take into consideration.
We cannot say now in that house only that accused was there.
No, if somebody was hiding there, if there are some materials showing that somebody was hiding
and
there,
then, my lord,
and somebody else has shot, that's a different thing. But circumstances and the materials before this court shows that he is the person who stayed there.
And my lord, one another aspect, how the victim can say that at the time of shooting at me, only accused was present inside the house of that activity.
No, she didn't say.
She have no supervisor
No, no.
to look.
She did not say
Whatever.
anything. She did not say anything.
Yes,
We are talking about the circumstances.
yes.
She said that like it must have been him.
Hmm.
I didn't see the gun, but it must have been, to me, it must have been him. That is what her statement.
Alright.
Now we'll have to see the circumstances. In the circumstances, whether his presence could be ruled out or his presence cannot be ruled out. That is what court has
My-
to see.
That's why, my lord, I have written that we not properly proved in the course of trial.
No, I mean, 313, he has himself admitted. 164 is there, he has confessed. Confessional statement can be a weak piece of evidence, but it cannot be totally thrown out. If there are some corroboration, the corroboration is there in 313 statement.
That is why
and I mean-
the visit this was case. Visit this was case what I have submitted. Supreme Court said proper proof.
The Supreme Court says like Supreme Court
And
says that only strong suspicion will not do. But only strong suspicion in the facts of the case you'll have to see. Correct. Now, in this case, what has happened?
for recorded conviction in the criminal trial. It is word for control. On the other aspect, under the accused has engaging in jail for more than 8 years. Only recorded 1 year, 1.5 years only to be the sentence. If it 32 will save only 1.5 years from the sentence behind. Or it may delay during the pendency of case. Paid.
Look, anything more? Okay. We heard Mr. M. Moja, the learned counsel, appearing for the accused, appearing for the petition. No, appearing for the appellant as an amicus, as a legal aid counsel, as an amicus query. Also heard Mr. G. Tado, the learned APP for the state, as well as J. Gini, also amicus, for the informant, for the victim as legal aid counsel. Full stop. Hearing concluded, judgment reserved. I have a question. To this माफी दिया ये को दे रहे हैं लेकिन मेरे तो मुझे भी
Item number 25.
there is no time now, Mr.
So
14.
this will no time, right? Like this mistake we cannot argue the case.
Yes.
So the matter may be upgraded and it may fix tomorrow after completion tomorrow.
No, that cannot be done. There are a lot of other matters are there.
Every time it is always listed in the last. And every time we cannot do the case.
What is the case all about?
Well, the fact of this case is that one particular, the client which my brother Kato represents, was involved in a POSCO case, and he was granted bail. And then there was some discrepancy that was detected by this honorable court in the form of a read petition. And thereafter, in the read petition was supposed for the revocation of his suspension because he was a DSP. And then thereafter, the court finds that there is a procedural irregularity in granting the bail in terms of notification number 17 of our High Court, where it is made mandatory that victim should also be given notice at the time of granting bail.
In POXO matter.
In POXO matter. And that is our Deepak Naik's judgment by our High Court and followed by Baramati Pangin judgment. So now what has happened is, Lord, there are so many advocates in this case. And then I don't know why every time the senior standing counsel for the High Court and my brother Kato is pressing very fast in this matter. And because of this, we come prepared, we argue, try to argue the matter. And this matter never reaches in time. And tomorrow, if this thing is happen, if the case is, if prayed by Martin sir, if it is listed tomorrow other counsel, we have some other matters, Milan. So therefore, this cannot be fixed as a matter. After 2 weeks, Milan, without any date. Because we don't want, because some conduct of some of the accused person, it should cause prejudice to the right of other accused.
How many accused are there?
24.
And all the counsels are representing Milan. And it is not a single day case to argue. And some of them are out of stations as well.
Madam, the urgency is, Madam, is my friend counsel.
No, I mean, there are other counsels also.
Yes, Madam.
So
With
you'll
the
have
consent
to
of the other party, Madam. What happened in this case, Madam?
and you'll have to fix a date.
Yes.
In consultation of all the
Madam.
counsel who are appearing in the case.
Madam.
So that way you'll have to fix. I mean, otherwise, I mean, somebody will argue, somebody will not argue. Then it will be.
Madam, exactly, Madam. This is the very reason, Madam, why, Madam, my time and again matter has been, Madam, the adjournment.
When
Now,
my
Madam,
brother called me, I have given my consent. The matter is finally taken up today and heard today.
Madam, what happened exactly?
I mean, argue the matter.
After show motor registration of this shoe motor case, Madam, Lani trial court has almost halted the proceedings, Madam. Maybe, Madam, there are some, Madam, as pointed out, there is an irregularity, Madam, not on our part, Madam. Irregularity maybe by mistakenly, Madam, it has been done by, Madam, the presiding officer, maybe, Madam. If we, Madam, see the, Madam, the records, Madam, admittedly, Madam, the hearing was done on, Madam, 28th of November, Madam. But then wrongly, Madam, the mention that 18 November, Madam. Clerical mistake, Madam. Madam, that has not been done, Madam. Of course.
Correct. No, now let us do one thing.
There is no stay for the trial.
There is no stay
No,
for
no,
Madam. There is no, Madam.
What is the urgency, my lord? It's only matter of cancellation of the bail, the procedural irregularity. It does not take away the personal liberty. As
the person is still already on bail.
Yes, Madam.
Only court wants to examine that why this procedural irregularity has happened.
Yes, Madam. That is the only limited.
That is the only limited this thing.
Yes, Madam.
And trial is still going on.
Yes, Madam.
Then what is the urgency? I also could not understand.
As I pointed to, Madam.
This is only a legal issue.
Legal
That
issues
can be
where the-
decided any on. It is not going to affect anybody. It is not prejudicing anybody.
Madam.
Then
However, Madam, as I pointed out, on 3 or 4 occasions, Madam, 4 occasions, Madam.
correct. I mean, see, I mean, there are. I mean, now if you pray for upgradation, there are bail matters, there are lot many other matters which are more urgent. I mean, I don't see any urgency in the matter. It is a legal issue which has to be decided. I mean, maybe a procedural lapse has been committed by the
Exactly,
court
madam.
while granting the bail, because in granting the bail, as Mr. Tara has pointed out, that there are some guidelines, and according to that, the victim has to be there.
Madam.
In anticipatory bail also, in POXO matters,
Correct.
the victim side has to be represented.
Madam.
Without hearing them, we can't do anything.
Madam, that is the only,
So,
madam.
so that is the only issue.
Yes,
So,
madam.
so I mean,
Yes,
now,
madam.
see, now that legal issue has already been settled. I mean, I have been taking this criminal bench in Guwahati High Court for last so many months. And in all matters, in bail, AB, wherever, we always hear them. So there is no violation of that thing. And no courts are also doing that. Now, that is a settled position now, because it's a direction from the Supreme Court.
No, madam.
Correct. Now, what is the issue involved there in your case? Nothing remains in your case.
Yes, madam.
Then
Madam,
what is the
even
urgency?
victim, statement of all the victims and
Then let the trial go.
have already done.
Let the trial go. What is anyways, I mean, I don't want to go on to the
Madam,
merit. I mean,
Madam,
uh,
may I put forward one suggestion with the consent of my brother? Who is counsel assisting? Perkin sir, senior counsel for the High Court.
he's,
My lord, Ismail clarification. Just a minute. My lord, what I'm pointing is, my lord, only for this, my lord, Ismail issues. My lord, I'm asking myself is, only for this Ismail issues.
no, small issue, no. We are not saying it's a small issue.
No, my lord.
That-
Only
it
irregularity
may-
has been done by the, my lord, the learned court
It
below.
it may require some examination of various
True,
case laws.
I admit, sir.
Correct. Because it has to come to some kind of way. I'm not saying it's a small
No,
issue.
my lord,
But thing is that the urgency, whether there is some urgency in the matter. But anyways, we'll fix it in the next week. I mean, you do it.
But may I put forward a view with the consent of my friends? The counsel who is assisting senior counsel Perkin sir may be appointed as a nodal counsel to coordinate with all the counsels who are appearing in this matter, and accordingly come out with a consensus.
Why don't you take the, you are more popular and you know many people. You can take the responsibility. Why are you asking here? You are the president, president of the bar. You know everyone. You coordinate and fix it.
On 14, I am
Huh?
officially demitting the office.
No, that's a different thing. But yeah, but you are.
After 2 weeks without any date, we will finalize the date. I'll coordinate with you.
Okay, you coordinate and like.
No, sir, after 2 weeks. Next week, sir, I am not there.
No,
The specific that
Sir,
Mr. Patin,
my lord,
specific that he will coordinate and give,
my lord, the problem is bar.
because other people are there, other council are there.
It's also there, and bar council election is also on, my lord. So we are totally engaged for 2 weeks, at least another 2 weeks.
my lord, another problem will be if fixed date is not given, my lord, all council will not represent, my lord. Lordship has already seen
That's why we said.
a long list of my lord council.
No, that's why.
My lord, another difficulty.
No, let us do one thing. Mr. Tara will coordinate and give a date to the court master.
Correct.
Court master after 2 weeks.
After 2
Matlab, the date will be after 2 weeks, but he will coordinate and give a date to him,
We are great.
the court master.
We are great.
Then you talk to senior Mr.
I will keep them.
Patin also.
And
and according
especially my brother Kato.
Anyway,
My lord, I am always present.
right, on the joint prayer of the parties representing in the case, let the matter be listed after 2 weeks on a date to be provided by, to be jointly provided by
Councils.
by the councils before the court master. So that the date will be given within, by tomorrow.
My lord. That's
By tomorrow, but otherwise you'll have to write the date.
Yeah.
Then order has to be signed.
correct.
So I'll keep it for 1 day, the order.
Yes, right.
So tomorrow you give the dates, then then we'll pass the order.
Fine.
Fine.
Public.